Welcome everyone to the House Committee on Judiciary and Hawaiian Affairs. Today is Wednesday, February 12th. It is 2 p.m. We are here in conference room 325. Welcome to all the testifiers, and members are either here or on their way, or some of them will be watching from their office and then join us later for decision making because they're trying to multitask and do many things at once. So for those who are wishing to testify today, I would request that you keep your testimony to 2 minutes, and I will kindly ask you to summarize at that point. If you are testifying via Zoom, I would ask you to keep yourself muted and your video off until you testify, and then turn your video off and mute yourself at that point. If you have technical issues, please use the chat function and contact these great folks who are helping me out with technology, and they can help you straighten that out. Don't send me any messages, though, because I don't get them. If you are disconnected for some reason, don't panic. Just try to rejoin, and then I'll find out that you've come back, and I'll try to fit you in so you can provide your testimony. If the power goes off in the building here and we have to reschedule the meeting, I'll make sure to post appropriate notice so everyone knows when we're going to be meeting. If you're testifying via Zoom, please don't use any copyrighted or trademarked images, because that kicks us off of YouTube, and that's a problem because we want the public to watch us. And if you're testifying here in the room, please come up to the podium so that everyone in TV land can see you and hear you, and then I'll ask you to, and please don't just stand on your testimony. If you could give us the highlights of your testimony, that would be helpful so that everyone knows what's going on. And if you've been in my hearings before, I ask you not to use jargon or acronyms or things. We really want to be understandable to the public. And so if you would help me by speaking in plain English, not legalese or in code, that would be great. I appreciate that. And I'd ask you to just conduct yourself with aloha and you know, avoid profanity or any rude behavior. It's okay to disagree, but let's not be disagreeable. We can all work together. Okay, let's go ahead and get started. We have a full agenda, and let's start out with House Bill 1002 relating to the Hawaii Correctional System Oversight Commission. This measure, beginning July 1st, 2025, extends the term of the Oversight Coordinator for the Hawaii Correctional System Oversight Commission, authorizes the Hawaii Correctional System Commission to review the coordinator's performance and make a recommendation to the governor as to whether the coordinator should be retained. And it clarifies that the oversight coordinator has the general authority to inspect agencies and correctional facilities without notice. And I want to acknowledge and thank the Chair, Chair Bellotti, for her work on this in the previous committee. So first up, we have the Department of Corrections and Rehabilitation. Director Johnson, welcome.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Tommy Johnson, the Director of the Department of Corrections and Rehabilitation. I'll summarize my one-page testimony. We provide comments on this measure. To us, it doesn't matter whether the coordinator is appointed for 2 years, 3 years, or even 4 years, as the original bill had indicated. And we have no problem with her having access to the facilities 24/7, because we want everyone to know that we're a partner in trying to make the system better. And so unannounced visits or inspections are fine with us, because whatever found will help us better the system. So thank you.
Sure appreciate your positive attitude about this partnership. Thank you, Director. Next up, we have Kristen Johnson, Hawaii Correctional System Oversight Commission, or the Chair of the Board of the Commission. Please
Aloha.
Introduce yourself, sir.
Hello, Chairman, Vice Chairman, members of the committee. Commissioner Mark Patterson, current Chair of the Hawaii Correctional System Oversight Commission. Thank you for allowing me to testify. I stand on my testimony, but I really wanted to reiterate, you know, when you folks formed the commission in 2019, we went into a process of hiring an oversight coordinator. COVID hit, and so we went almost 3 years with no staff and no oversight coordinator, and that has taught us a lot. Yeah, and now since 2022, with the hiring of the oversight coordinator, we stand in front of you with everything that you've given us since in terms of staff and an oversight coordinator, asking you to really consider giving the commission a little bit more ability to manage our leadership of our staff so that we can truly sustain all the work and the reform efforts that we hope to do in partnership with the DCR at this particular point in time. The bill, if we're looking at 4 years or more, will allow us that ability to manage the leadership, manage the reform efforts, and everything that we're putting into play at this particular point in time. So I sincerely thank you for this time and opportunity. Thank you.
Thank you very much. Next, we have Kat Brady, Community Alliance on Prisons.
Good afternoon, Chair Tarnas, Vice Chair Poipoi, and members of the committee. Kat Brady testifying in strong support of this measure for Community Alliance on Prisons. I know that all representatives know 2 years is not enough time to really get traction and make change. So we were kind of happy with the 4-year extension, but actually after doing some research and talking to other people, I'm on all sorts of national lists, 6 years would be better because then they would be not subject to politics. It would be in between the terms, so that would be really good, and we support that. It was changed from 4 years to 3 years with no explanation, so nobody knows what that's about. So we're pushing for a 6-year term so that the commission can actually focus on its mission, which is to help the department transition from a punitive to a more rehabilitative, restorative system, and it just would give them time to actually do that. So thank you so much. We hope you support this bill.
Thank you very much. The other testimony we've received from individuals and also from ACLU Hawaii are all in support, but they've not indicated they are here to testify unless they've changed their mind. Carolyn, yes, please come on up. We didn't know you were going to be here, so please come on up and introduce yourself and proceed.
Chair Tarnas, Vice Chair Poipoi, and members of the committee, I'm Carolyn Eaton. I am a taxpayer, and I bring energy and hope to this legislative session and really I've followed the Hawaii Correctional System Oversight Commission practically since its first meetings, and I'm a very strong supporter and want to second the idea that our coordinator serve a 6-year term.
Thank you very much, Ms. Eaton. Anyone else wishing to testify on House Bill 1002? If not, questions, members? I would, Chair Bellotti, did you want to mention anything?
If you
Later, or you want to do it later? We'll do it later?
Yeah.
Okay. I just so members and the members of the audience know and members of the committee know, I've talked to Chair Bellotti and requested that she provide some background information about her rationale for the changes in the bill in a previous committee, but we can discuss that during decision making. Okay. No questions? Okay, if not, we'll move on to the next measure. Thank you very much to all the testifiers. Next measure, House Bill 677 relating to identification. This measure requires the Department of Corrections and Rehabilitation in collaboration with various agencies and upon request of the inmates to assist inmates in obtaining the inmate's civil identification card, birth certificate, social security card, and other relevant identification necessary for successful reentry into society as soon as practicable. It requires the Department of Corrections and Rehabilitation to initiate the process of obtaining identifying documents for inmates released to work furlough, extended furlough, or community placement programs by providing the forms necessary for the inmate to obtain civil identification cards and other identifying documents to the inmate as soon as practicable. First up, we have Director Johnson, or his designee.
Good afternoon, Chair, Co-Chair, Committee. We currently support bills.
Could you introduce yourself, please?
Oh, yeah. My name is Christy Yokoyama. I'm the Acting Corrections Department Program for Reentry Office, okay? So we currently support Bill 677 with regards to, we are currently working with the city and county to get the new machines for the rest of our facilities and also to replace the one existing at Halava. So we will continue our efforts with city and county. We also have continued our efforts with birth certificates and also with social security cards. So if you have any questions, you can just let me know.
Thank you very much. Appreciate it. We have written testimony from the Department of Human Services and the Office of Hawaiian Affairs. Are they here today? Office of Hawaiian Affairs, please proceed. Ms. Woodward.
Aloha, Chair, Vice Chair, and members of the committee. McKenna Woodward on behalf of the Office of Hawaiian Affairs in support of this measure today. Native Hawaiians continue to be disproportionately impacted by Hawaii's criminal justice system, comprising approximately 37% of the state's correctional facilities, while representing only 21% of the state's general population. So ensuring those who have served their sentence receive their identifying documents in a timely manner, meaning before their release, ensures they're able to secure housing, apply for jobs, and travel back to their homes if incarcerated out of state. So I'd respectfully ask for an aye vote and mahalo for your consideration.
Thank you, Ms. Woodward. And we have Hawaii Correctional System Oversight Commission. This time we get our Kristen Johnson.
Yeah, we got to mix it up a little bit. Hi, everybody. I'm Kristen Johnson. I'm the Oversight Coordinator of the Hawaii Correctional System Oversight Commission. We do support this bill. We want to acknowledge DCR's really hard work and partnerships with the DMV.
DCR.
The Department of Corrections and Rehabilitation.
We want to get everyone used to saying that. It's a new name. A new name, a new paradigm. And
That's
so let's
true.
keep saying the name.
Sure.
Please, go ahead.
Okay, so we do want to acknowledge the Department of Corrections and Rehabilitation's partnership with the Department of Motor Vehicles. But there's still a lot of work to be done, and so we want to acknowledge that as well. We really believe that reentry starts on day one, and so we agree with the as soon as possible, and really, really agree with day one. So thank you for the opportunity to testify.
Thank you very much, Coordinator Johnson. Next, Cap Brady, Community Alliance on Prisons.
Aloha again. Community Alliance on Prisons is in strong support of this measure. We did a little research. 21 states have laws aimed at helping folks get ID. 17 states have permanent ID cards that they give to people who are being released. Hawaii and 9 states provide state ID cards: Alabama, Alaska, Arizona, California, Florida, Georgia, Illinois, Texas, and Washington. We think it's really, we know it's really, really important, because without ID, you can't open up a bank account, you can't get a job, you can't find a place to live. So it's absolutely crucial for reentry, and we really support this bill, and I hope you guys too.
Thank you very much. We received written testimony and support from Waikiki Health, Opportunity for Youth Action Hawaii, and from numerous individuals, including Carolyn Eaton. Would you like to provide testimony today? Yes, no? If you do, come on up, please. Okay, thank you very much. I refer everyone to Ms. Eaton's written testimony. That's all the testimony we have received on House Bill 677. Is there anyone else here wishing to testify? Yes, we see former Representative Ganadin.
Sonny Gannon, Deputy Public Defender for the Office of Public Defense, Office of the Public Defender. We are in support of this measure. Apologies you didn't get our testimony. Just for a bit of context, this comes from a finding of the Native Hawaiian Justice Task Force report from 2012, in which individuals were asked what is the most pressing issues facing Indigenous peoples in this community regarding incarceration. This was one of the findings. This was made law in 2017 by this body. It was the first bill passed by former Representative Cedric Gates. It's taken this many years to get this far, with much consternation, with possible partnerships with the Department of Human Services, the DMV, other organizations. We hope that you pass this measure.
Thank you very much. Anyone else wishing to testify on House Bill 677? If not, questions, members? Representative, please proceed.
Thank you, Chair. Excuse me. Thank you, Chair. I just wanted to make a comment to appreciate the directors, commission, and everyone, taxpayer, just your heart to promote this important part of our society, and I'm very motivated and inspired by all of you, so thank you.
Thank you, Representative Shimizu. Any other questions or comments? If not, we'll move on to the next measure. Thank you to the testifiers. Next, House Bill 1183, relating to allowance on service retirements. This measure includes certain law enforcement administrators and employees of the Department of Law Enforcement as Class A members of the pension and retirement systems, and provides guidance for the computation of retirement benefits similar to police officers. First up, we have testimony from the Department of Budget and Finance. I refer members to the written testimony from Department of Budget and Finance. Next, we have the Department of Human Resources Development.
Good afternoon, Chair, Vice Chair, members of the committee. Thank you for the opportunity to testify in support of this measure. We provided written testimony, but I'll just summarize that
And
DHERD.
introduce
Sorry,
yourself
I'm
so
Brenna
everyone knows
Hashimoto,
you.
Director of the Department of Human Resources Development.
Thank you for being here,
Also known
Director.
as DHERD. We are in support of this measure. We believe it's an important step in the right direction to make sure that we can incentivize recruitment and retention of individuals within the Department of Law Enforcement and the leadership roles, to incentivize individuals who may already be Class A or Class B members and would have to relinquish that status in order to accept positions such as a director or deputy director and some investigator positions. And so we're in support of this measure. Thank you.
Thank you very much. Appreciate it. Next, we have the Employee Retirement System of the State of Hawaii with comments. Welcome, sir.
Good afternoon, Chair Thomas, Vice Chair Poi Poi. I'm Thomas Williams, the Executive Director of the Employees Retirement System. And I'm pleased to have the opportunity to testify this afternoon and provide comments. You do have our written testimony. It is intended to provide clarifying and technical amendments that is intended to help implement the intent of this particular bill. And of course, we're willing to work with any of the stakeholders to assure that those amendments are incorporated. And of course, I'm available to the extent you have questions. Thank you very much.
Thank you, Mr. Williams. And finally, we have the Department of Law Enforcement. Mr. Asuka, welcome.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Brandon Asuka. I'm the Executive Officer for the Department of Law Enforcement. So the Department of Law Enforcement strongly supports this measure. As an agency as a whole in its infancy stages, we are concerned about, our legacy and, I guess, succession planning. And although we like to promote from within, we'd like to give the governor the ability to appoint the most qualified individual to lead our agency. Thank you.
Thank you very much. That's all that we've had sign up to testify on this measure. Is there anyone else wishing to testify on House Bill 1183? If not, questions, members? Any questions? If not, we'll move on. Thank you very much to the testifiers. Next measure, House Bill 1045, making emergency appropriations for law enforcement personnel costs. This measure makes emergency appropriations for fiscal year 24-25 to the Department of Accounting and General Services and the Judiciary for payroll and fringe benefits for affected Department of Law Enforcement personnel. First up, we have the Judiciary with written comments in support. And next, we have Department of Budget and Finance.
Neil Meir here for the department. What this bill does is provide.
In support or
In
against?
support.
Okay.
This is our bill. What this bill does is provide the fringe benefit cost. Because when payroll is run, one department pays for another department's employees. They run it through an account and fringe benefits are assessed. When the original budget was put in, all the funding for the sheriffs were in law. And then what the legislature...
That's a budget category you're referring to.
No, it was in the Department of Law Enforcement.
Yes.
What the legislature did in its wisdom is moved out the salary money and put it in judiciary and then put it in the DAGs, Accounting and General Services. But they put only the salary money in. So when the payrolls run, the fringe benefits are assessed because they're not a general fund program. So this pays for the fringe assessment. And we also have a declaration for the expenditure ceiling in '25.
Thank you very much. Next, we have Department of Law Enforcement.
Good afternoon, Chair,
Afternoon.
Vice Chair, and Committee. So my name is Russell Fong. I'm the ASO for the Department of Law Enforcement.
What's an ASO? You got to tell us all about that.
Administrative Services Officer.
Thank you. Thank you.
Sorry about that.
That's okay.
And so the Department of Law Enforcement strongly supports this House bill. And as Budget and Finance actually said that when everything was transferred over, only the salary went over and not the fringes. So this bill, House Bill 145, covers the payroll and fringes benefits to the DLE personnel. So, and it gets transferred from the Department of Accounting and General Services and the Judiciary. So the amounts that the appropriations is $7.1 million, and that's broken down by 2.4 from the Department of Accounting and General Services, and the difference is 4.6 million for the Judiciary. So thank you for this time.
Thank you very much. Is there anyone else wishing to testify on House Bill 1045? If not, questions, members? No questions? Thanks very much to the testifiers. We will move on to the next measure, House Bill 664, relating to gun violence prevention. This measure establishes the Office of Gun Violence Prevention to conduct community outreach on gun violence prevention, develop and administer a grant program for gun violence prevention, and develop and administer a gun violence resource bank. The measure establishes the Gun Violence Prevention Special Fund and appropriates funds into and out of the special fund and appropriates funds. First up, we have the Attorney General on Zoom. Oh, in person, even better. Thank you so much. Please come on up, introduce yourself, proceed.
Good afternoon, Chair Tarnas, Vice Chair Poy, and members of the committee. My name is Melina Sanchez. I'm a Deputy Attorney General with the Department of Attorney General's Office. We provided written testimony with comments on HB 664. First, since the bill involves grant monies, we recommend incorporating appropriate standards for the awards of grants by the new office. Second, we'd like to point out that there appears to be overlapping responsibilities with the proposed new office and the existing Gun Violence and Violent Crimes Commission codified under Chapter 134C of Hawaii Revised Statute. And what we recommend is to avoid any confusion or duplication of efforts, we recommend that the committee consider amending the bill, first to consolidate the Gun Violence and Violent Crimes Commission responsibilities and into the new office, and then repeal Chapter 134C. We'd be happy to work with the committee, and thank you for allowing me to testify. I'm
Certainly,
available.
thank you for your testimony. Next, we have written testimony from the Department of Budget and Finance. Anyone here in person? Nope. Next, we have testimony from the Department of Law Enforcement in writing. You want to present in orally? Nope. Okay. Next, we have testimony and support from the Brady Campaign to Prevent Gun Violence in writing. And you want to present in person? You're most welcome to. Briefly. Deborah Namad.
Good afternoon, committee members. Thank you for this opportunity. I'll be short. I'll stand by my written testimony and just emphasize that now that the U.S. Supreme Court, in its wisdom, has decided that there'll be more guns allowed on our streets, that this kind of common sense measure to study gun violence, to educate, to gather the statistics is needed now more than ever. Thank you very much.
Thank you very much. Next person said they wish to testify is Sarah Sumadi, Everytown for Gun Safety. Welcome, please proceed.
Hi, thank you for having me. My name is Sarah Sumadi. I'm the Regional Director of Government Affairs for Everytown for Gun Safety, which is the largest gun violence prevention organization with 11 million supporters across the country, and here in support of HB 664. This bill would bring Hawaii in line with peer gun safety states which have such offices like California, Washington, Massachusetts, Illinois, and New York. An Office of Gun Violence Prevention enables the state to approach the crisis of gun violence from every angle by serving as a centralized hub that ensures laws are reaching their maximum potential and increasing public awareness of things like secure firearms storage and ERPO, as well as administering funding for life-saving violence intervention programs. Thank you so much for your time, and we urge you to vote in favor of this legislation.
Thank you very much. Next person who said they wish to testify is Erica Yamauchi, Everytown and Moms Demand Action Hawaii Chapter.
Mahalo, Chair, Vice Chair, and committee members. I'm Erica Yamauchi. I live in the Kaimuki area of Honolulu. I'm a gun violence survivor, mom of 2 in our public schools, and I also teach myself at University of Hawaii. I'm standing in strong support of this bill and representing our 3 local groups and more than 2,000 supporters statewide. I just wanted to highlight one part of my written testimony in that I'm really excited about the possibility for this kind of office in the state to not only have the ability to convene and coordinate efforts to meet our gun violence prevention goals, but as well as pull down federal funding, which I think is really critical. We're leaving a lot of money on the table when it comes to community violence intervention right now. And that can come from both the federal government as well as philanthropy. So I just wanted to highlight that. Thank you for the opportunity to testify.
Thank you very much. Next person who wishes to testify is Michael Rice on Zoom, not present, in opposition. Next person who said they wanted to testify is Jessica. Don't have a last name, not present. Next person that said they wanted to testify is Todd Yukutake, in person. Or on Zoom? Okay, not present, with comments. Next person that said they want to testify is Elna Nagasako. Welcome. Please proceed.
Aloha to the committee. I'm here in support of HB 664. So I'm a physician with a background in public health as well as healthcare quality improvement. And although I was born and raised in Hilo, I spent many years in Missouri working on community health with a variety of community organizations, academic faculty, as well as a regional hospital system there. And so from that experience, I just want to attest that it is essential to have an impact. If you're going to have an impact on a community health outcome, that it's essential to have data to focus efforts, a backbone organization to help convene different stakeholders, as well as a hub for community partnerships. So having an Office of Gun Violence Prevention would allow resources to be sent in the areas where they're most needed. It would avoid duplication of services and efforts and engage community members so that these interventions can be successful and effective. Now, although Hawaii has a strong record in the area of gun safety, the rate of gun deaths in the state has increased markedly over the last decade, which actually outpaces the rate of increase in the national statistics. So protecting the lives of our community members and making prudent use of limited resources, it's too important to have efforts that are unfocused, uncoordinated, and ineffective. And so for this reason, I really hope that you support this bill, and thank you for the opportunity to testify.
Thank you, Dr. Nagasako. We have numerous other testifiers, total 37 in support, 9 in opposition, 3 with comments. I see many other people here that look like they might want to testify. I don't know if anyone signed up, but could you raise your hand if you want to testify? Okay, anyone else for any future bill, if you have not signed up to testify, I need you to go over and sign up over here at the table so that I can be better prepared. But for this bill, let's go ahead and start with you first, and then there was someone over here that wanted to testify. Yes, please go ahead. Introduce yourself and proceed.
My name is Chairman Tarnas, members of the committee. My name is Chris Marvin. I'm an Army veteran who lives in Nu'uanu. I'm in strong support of this bill. I did submit written testimony, just did not click the radio button to also be in person, but here I am. So thank you for the opportunity. Strong support of HB 664. I'm testifying in my individual capacity, but I also am a member of the National Everytown Veterans Advisory Council, which is a group of veterans who advises the nation's largest gun violence prevention organization. And so I see what has been done in other states. Hawaii always hopes to be a leader and is a leader in gun violence prevention, but quite frankly, many other states are outpacing us. Massachusetts passed an omnibus bill last year. California, Illinois, New York, New Jersey are all doing amazing things. they have done similar things to this. They have created offices of gun violence prevention. So to keep up with, I think Sarah called them our peer states, this is something that we need to do. Since the Bruin decision from the Supreme Court, the gun purchases registrations in the state are up 280%. So that has opened the floodgates for people who want to buy guns, though the process is somewhat onerous. They're accomplishing this. They are buying guns. There are more guns out there. More guns means more gun violence. And so it only makes sense that we have a centralized place at the state level to deal with gun violence, to help legislators have data when many of these bills are coming through your desks all the time. And with that, I would just strongly ask you to pass this bill and give us an Office of Gun Violence Prevention. Thank you.
Thank you very much. The person over here that wanted to testify, please come on up and introduce yourself. Thank you.
Hi, thank you for the opportunity to testify. Should I go talk to her after this?
After your testimony, if you could please give her your name and affiliation, that'd be great.
Sure. So my name's Deborah Harada. I live in Kaneohe. I'm coming forward because I've witnessed firsthand the impact of gun violence on family members of mine. I would encourage you to, I'm in favor of this bill. My hope is that we can do the preventative work to avoid the tragedy that we see and hear about over and over due to gun violence. Preventing gun violence is in the best interest of everyone. Creating an office at the state level would allow us to continue Hawaii's leadership in this area and protect our communities with a coordinated effort. Thank you.
Thank you very much. If you could, thank you very much. Is there anyone else wishing to testify on House Bill 664? If, yes, please. Welcome, Mr. Dunn.
Thank you very much. As members of the committee, you remember I'm Dennis Dunn, the retired director of the Victim Witness Kokua Services in the prosecutor's office. And I'm here testifying in support of this measure because I've always said an ounce of prevention is worth a pound of cure. If I could have done anything over my career to help to prevent the violence that I saw visited on the people that I worked with, I would have done it. And I think this is something that we can do. It's an easy measure. Some people seem to be opposed because they think it's bureaucratic. It's something that will allow all of us to focus our efforts. And I think that's, as other people have spoken, is what we need. We need to focus our prevention efforts on gun violence. Thank you.
Thank you very much. Anyone else wishing to testify on House Bill 664? If not, questions, members? Representative Shimizu, please proceed.
Excuse me. Thank you, Chair. I'm not sure who I'm addressing this question to, but
you need to pick.
Okay, I'll pick eeny, meeny, miny, mo. Let's see. Attorney General, can I ask a question, please? I think your testimony referenced an existing, was it your testimony
Yes,
that
it was
existing
134C.
Existing gun violence?
Yes, it
and
was the
Violent Crimes
Gun
Commission?
Violence, Violent Crimes Commission, codified under Chapter 134C.
Right. So that is an existing commission that is operating to this date?
My understanding it is.
Okay. So I guess my question would be, what is the difference between the commission, the existing commission, and this new office that's being proposed?
I think in our comment section, we gave the responsibilities, there was an overlap. So the way we viewed the bill was that it made more sense to have them include their responsibilities within the Department of Law Enforcement, to have just one agency looking into it rather than having various people within the public, the judiciary, the attorney generals. There's a list of various people who have to be members of this commission, have meetings and so forth. So by incorporating the powers and duties within this new office, it will make things much more better, and people can go into that.
I'm sorry, I didn't get to read your testimony thoroughly. So are you saying that the commission and this new office would be combined into one entity?
No, not combined, just the powers and the duties would be the responsibilities of the current commission under 134C would be incorporated within the law enforcement new office. That's how we perceive the way the bill was written.
Okay,
And
so
then repeal the 134C.
So you'll have two separate entities still yet?
No, you would repeal, once we incorporate the responsibilities of the current commission into the
Okay.
new office, we would recommend repealing
Oh,
134C.
okay. I'm sorry. I thought that's what I asked, if you would be combining it, and you said, I heard no, it's not going
Well,
to be
combining
combined.
in the sense that we wouldn't require the same commission members.
Uh-huh.
It would be primarily the law enforcement.
Right, so you would have one entity versus
Correct.
two separate entities?
Correct.
And this would be under the Department of Law Enforcement?
Correct.
Okay, that's very important. Thank you very much. Thank you, Chair.
Certainly, thank you, Representative. Any other questions, members? If not, thanks very much to the testifiers. We'll move on to the next measure. House Bill 508 relating to fireworks. This measure amends Act 67, Session Laws of Hawaii 2023, to appropriate funds for the Illegal Fireworks Task Force for fiscal year 25-26 and fiscal year 26-27, and to extend the sunset date of the act from June 30th, 2025 to June 30th, 2030. First up, we have Department of Transportation. By Zoom, please proceed. If you would please unmute yourself, turn on the video, and provide testimony, Department of Transportation, that'd be great. If not, we'll move on, and maybe they'll come back when, they'll alert us when they come back. Next up, we have Department of Law Enforcement.
Good afternoon, Chair, Vice Chair, and members of the committee. I'm Jared Ridula, the Deputy Director for Law Enforcement. Thank you very much for hearing this bill. The department is in strong support of this. The main benefit of this bill is that because it's task force funding, it will allow us to pay the other agencies that work with us, and importantly, the very expensive logistics that go with enforcing the law regarding fireworks. Thank you very much.
Thank you, Deputy Director. Next, we have Honolulu Police Department.
Good afternoon, Chair, Vice Chair, committee members. My name is Ernest Rebella. I'm a lieutenant with the Narcotics Vice Division of the Honolulu Police Department. The Honolulu Police Department supports this bill, and in general, we support all legislation which helps to reduce the use of illegal fireworks to prevent tragedies such as the most recent one this past New Year's Day. Thank you for this opportunity.
Thank you very much for your testimony. We've received written testimony from numerous individuals, and one other person has said they would want to provide testimony. That is Stephanie Kendrick with the Hawaiian Humane Society on Zoom. Oh, in person.
Thank you, Chair, Vice Chair, committee member Stephanie Kendrick with the Hawaiian Humane Society. We're in strong support of this measure, and you have our written testimony. I just wanted to share, the task force has interdicted nearly 200,000 pounds of explosives at our port since its inception not that long ago, and we think they've more than proven worthy of financial support from this body, and we hope that you'll pass this measure. Thank you.
Thank you very much. In total, we've received 19 testimonies in support, 4 in opposition. And that was all the individuals that said they wanted to provide oral testimony. Is there anyone else here wishing to testify on House Bill 508? If not, questions, members? See? No, okay. Okay, no questions. Thanks very much to the testifiers. We'll move on to the next measure. House Bill 648 relating to guardianship and conservatorship services. This measure establishes a 2-year pilot program in the probate court and family court of the First Circuit to fund certain guardianship and conservatorship related court resources in situations where the respondent does not have sufficient funds to pay for one or more of the resources, and the court has deemed the resource or resources beneficial. Measure also requires the judiciary to submit reports to the governor and legislature and appropriates funds. First up, we have the judiciary with written testimony in support. In person. Please introduce yourself.
Good afternoon, Representative Tarnas and House Chair Tarnas and Vice Chair, members of the committee. I'm Roland Lee, Director for the Office of the Public Guardian, and I'm not sure if I'm speaking on behalf of the judiciary as probate, or if this is going to be for testimony.
Roland, I think we have you as a later testifier, but you can just go ahead and present your testimony.
Thank you very much.
Yes.
So the Office of the Public Guardian is in support of House Bill 648 as it stands, with funding for Kokua Kanawai services and for guardian ad litem services in a 2-year pilot program to expand services for people under guardianships or that have something to do with guardianships. But what we would like to respectfully ask the legislator to do is to delete line 17, which quote says, "and physicians, letters, and," unquote, on page 1, and also remove lines 1 through 4 on page 2, and also remove lines 12 to 17 on page 3. And this is in regards to professional evaluations. We support the Kokua Kanawai services as well as the guardian ad litem, but as far as the evaluations, we really do feel that the burden of proof should be on the petitioners and that the court should not be put in a position to have to furnish information to itself by administering evaluations for a respondent, because that might be disadvantageous for the respondent. So you have a written testimony, and I'm here for any questions.
Thank you very much.
Thank you.
I would encourage you to submit your testimony on time in the future.
I
It's
apologize.
very difficult for us to read your late testimony and be able to be prepared to incorporate your suggested amendments if we get them late.
I
And
apologize.
Yeah, it's just, if you could just try
Thank
better
you.
next time. Yeah, this committee really tries to alert the public well in advance for our hearings. We publish our hearing notices well in advance with the hope that you do submit on-time testimony. And you're a busy guy, I get it. But in the future, that would be very helpful if you would submit
Thank you.
testimony on time. Thank you. Okay, let's move on. Daintry Bartoldes, Hawaii State Council on Developmental Disabilities, or her designee. Jay?
Aloha, Chair, committee members. My name's Chase Silver. I'm with the Hawaii State Council on Developmental Disabilities. I will summarize our testimony, which is offering comments. So we, as the council, have been hosting a working group at the pleasure of Representative Tarnas for a guardianship conservatorship working group that we've been meeting since 2023. It was designed or started to kind of identify if the Hawaii would be really good for a uniform law. And then that working group quickly shifted and realized that Hawaii was not ready to do a uniform law in this area. But then we shifted to what are some of the issues that this particular guardianship and conservatorship courts face. And in those conversations, which we've had for about a year now, this specific measure is one of the discussions that came out of it. I just wanted to highlight that we're offering comments just because of the nature of the working group and the different people we're representing. But this did come out of discussions, and these were needed tools that would help the courts make better decisions. Thank you.
Thank you very much. We've received written testimony and support from the Executive Office on Aging, AARP Hawaii. Also, testimony from Lou Erdicek.
Yes.
Here?
Good
On Zoom,
yes.
please proceed.
I'm on Zoom. Good afternoon. Good to see you, Representative Tarnas.
Good to see you, sir.
We participated in the working group, and so obviously we're in support of the bill. The working group couldn't agree on much, but they did agree on this. So I think that means that it's obviously a good idea if everybody was able to support it. These are basic due process protections that, quite frankly, Representative, I'm a little surprised that the judiciary budget doesn't already include this. I'm surprised that there isn't currently in the law a provision for these kinds of services for people that are indigent, because becoming a ward under a guardianship is while some people need to have a guardian, it's clearly a major infringement on a person's life and their liberty. So we think this should be in the base budget of the judiciary. So I think to that extent, this pilot program is an excellent idea. I think it'll demonstrate the need for it, and So we appreciate your support. Thank you.
Thank you very much. There's numerous other testimonies in writing and support. Is there anyone else here wishing to testify in person? On Zoom? If not, questions, members? If not, no questions, just thanks to the people who are working together on this task force, and thanks to Shay with the Hawaii State Council on Developmental Disabilities for facilitating the group. You've done a lot of good work, and it's I'm glad to see that we've got a measure that we can move forward. There's a lot of other work that we need to do, but I appreciate your good efforts. Thank you. And to everyone else who's been participating. It's very helpful. Thank you. Okay, let's move on to the next measure. Just so if you notice on the hearing notice, we had House Bill 1000 relating to identification processing. We deleted that from the agenda. It's because the Senate vehicle is moving, and we're going to wait for the Senate vehicle to come over. So that's why we took it off the agenda. We've got a lot of bills we're trying to hear on this side in the House, so we chose to wait for the Senate vehicle to cross, and we'll consider it when it comes over to the House. Next measure, House Bill 1001, relating to settlement of claims related to the Maui wildfires. This measure makes general fund appropriations for fiscal years 25-26 and 26-27 to fund the settlement of claims related to the Maui wildfires. It establishes the Maui Wildfires Settlement Trust Fund to be administered by the Attorney General. First up, we have the Attorney General on Zoom.
No, in person.
In person. Oh, lucky me.
Good afternoon.
Good afternoon, sir.
Deputy Attorney General Randall Nishiyama. We submitted our written comments in support of this bill. This bill funds the state's share of the wildfire settlement agreement for the compromise and settlement of claims. I'm available to answer any questions that you may have. Thank you.
Thank you very much. We've received written testimony and support from Maui County Council Chair Alice Lee. And we received testimony from Tom Yamachika, Tax Foundation of Hawaii, on Zoom. Please proceed.
Thank you, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. We'll basically start on our written comments. Sorry they're late. And we do basically agree with, enacting measures to keep litigation costs down and get necessary monies to the affected people as expeditiously as possible. I'd be happy to answer any questions. Thank you very much.
Thank you very much. That's all the testifiers that have signed up to testify or sent in written testimony. Is there anyone else wishing to testify on House Bill 1001? If not, questions, members? Representative Shimizu.
Thank you, Chair. Question for AG, please. I read someplace that the settlement was for a 4-year payout, and you are asking for a 2-year payout. I was just wondering the rationale on that.
We're holding the monies in trust for the period of time. So while there is a 2-year appropriation period, at this point, the timeline is rather unclear as to how quickly we can get the settlement payments out. So that's why we're asking for the monies in two years.
All right, thank you. Thank you, Chair.
Certainly, thank you. Any other questions, members? No? If not, thanks very much to the testifiers, and thanks to everyone who worked together to actually come up with this global settlement, and to the Supreme Court for saying, yes, we can move ahead and actually start paying those who qualify for these settlement of claims. Okay, next bill. House Bill 1174, relating to the procedure for payment under protest lawsuits. This measure allows for the interest earned on payments under protest in the litigated claims fund to be paid in non-taxation cases if the claimant prevails. It also establishes a procedure for the disposition of monies and refiling of actions when a payment under protest suit is filed prematurely. First up, we have Tom Yamachika with Tax Foundation of Hawaii. Please proceed.
Thank you, Chair, members, Tax Foundation of Hawaii, Tom Yamachika speaking. This bill is similar to House Bill 1805 that was introduced and heard by this committee and passed out last session. The basic issue is that the statutes provide a means of challenging payments made to the government when the payer doesn't think it's lawful or fair. But what has to happen is that the lawsuit has to be filed within 30 days after the payment. Now, because of a Supreme Court decision that happened that requires a formal agency action before the lawsuit can be maintained, it's possible for an agency against whom this kind of suit's been filed to say, oh, I'm sorry, we haven't reached a final decision yet. And if they hold on to the money for 30 days, they can basically keep it without any chance of judicial review because the time period will have lapsed. So this bill will fix the loophole by saying, okay, in that kind of situation, agency, you got 6 months. If you decide within the 6 months, you can keep the money, but the court suit goes forward. If you don't, you got to give the money back. So that's basically what this bill does. I'd be happy to answer any questions.
Thank you very much. That's all the testimony we received on this measure. Is there anyone else wishing to testify on House Bill 1174? If not, questions, members? Seeing none, thanks very much for your good explanation, Mr. Yamachika. We're going to move on. Next measure, House Bill 990, making appropriations for claims against the state, its officers, or its employees. This measure makes appropriations and approves payments for claims against the state, its officers, and its employees. First up, we have testimony from the Department of Transportation on Zoom. Please proceed.
Yeah, good afternoon, Chair, Vice Chair, members of the committee. My name is Larry Dill. I am the Highways Administrator for the Department of Transportation. I see that I have not updated my Zoom profile, so I want to clarify, I am the Highways Administrator and no longer with just the Kauai District. But at any rate, DOT does support this measure, and we want to express our gratitude to the Office of the Attorney General for their support and hard work in bringing these cases to settlement. Thank you.
Thank you very much. Next, we have testimony and support from the Attorney General in person. Lucky us. Thanks for being here. Please introduce yourself and proceed.
Good afternoon, Chair, Vice Chair, members of the committee. I am Deputy Attorney General Skylar Cruz. We support this bill. The bill has 8 claims on it, which total $2,338,335.75. Those claims are described in the testimony, attached to our testimony in Attachment A. Since the bill was introduced, 9 new claims have been added for a total of $3,572,898.47. Those claims are described in Attachment B to our written testimony. With the new claims, there are a total of 17 claims for a total amount of $5,911,234.22. We ask that the bill be passed with amendments to add the 9 new claims. I'm happy to answer any questions that the committee may have. Thank you.
Thank you very much for your testimony with the updates on the newly settled claims. Next, we have testimony from the Department of Budget and Finance. Not present. I refer members to the written testimony. Is there anyone else wishing to testify on House Bill 990? If not, questions, members? Seeing none, we'll move on. Thank you to the testifiers. Next measure, House Bill 997, relating to court-ordered payments. This measure requires the judiciary to contract with a collection agency or licensed attorney to collect delinquent court-ordered fees, fines, sanctions, and court costs. It repeals the authority of the judiciary to contract with a collection agency or licensed attorney to collect delinquent restitution. It expressly allows courts to specify a period of time or installments for payment of fees and restitution, requires courts to hold payment compliance hearings once per year or as soon as practicable until all fees, fines, and restitution are fully paid, and requires a defendant to appear and show cause if the defendant fails to pay in full within a time specified by the court or fails to pay 3 consecutive installments. The measure also makes corresponding amendments to related statutes. First up, we have the Attorney General. Tricia Nakamatsu, welcome.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Attorney General Tricia Nakamatsu, appearing on behalf of the department. The department is in strong support of this bill, and we thank you for hearing it, Chair. This bill is meant to address a Supreme Court case that just came out last year in 2024 called State v. Fay. That decision upended, basically, a longstanding practice in our district courts whereby the courts would set proof compliance hearings that help to facilitate situations where the defendant is unable to pay their fines, fees, and restitution all at once, and so essentially a payment plan, or they're allowed to pay over time. So this bill would provide a couple of different solutions to address that. First, for fines and fees. Currently, criminal cases the fines and fees can't be referred to collection agencies, as is routinely done in traffic cases. So this bill would allow for fines and fees to be sent to collections. However, it would remove the ability for juvenile monetary assessments or restitution to be sent to collection agencies. We just, for various reasons, don't feel that that's appropriate, and there are other ways that those things can be handled. Okay, so that's one thing. In addition, in cases where the court feels it's appropriate to allow somebody to pay over time, particularly in restitution, it would apply to fines and fees, but most important perhaps in restitution cases, the current statute and one of the key words that State v. Fay turned on was the word default, when someone defaults in their payments. But there's currently no definition for what default means or how the court would determine when someone is in default. So this bill would provide both a definition and a mechanism for the court to determine when default occurs. And it would give the court's discretion on how often to set proof compliance hearings. It would make certain requirements. If somebody is in fact found to be in default, they'd have to come back a little bit more often, though still at the discretion of the court. And let's see, there was one other thing, is that, essentially this would bring things back to the way they were pre-Fay, in the sense that proof compliance hearings would be allowed, so it wouldn't necessarily require any additional resources or manpower in that sense. Available for questions, if any.
Thank you very much. Next, we receive written testimony from the judiciary with comments. Not here in person. Next, we have testimony from the public defender. Mr. Ganadin, welcome.
Good afternoon, Chair, Vice Chair Sonny Gannon, Deputy Public Defender, Office of the Public Defender. Apologies, our testimony came in a bit late. We did testify, of course, on the sister measure, SB 1316, which was heard by the Judiciary Committee in the Senate this morning. This bill is about charging defendants who are not yet in default. We implore the members of the committee and those listening to actually read the State versus Fay case. It's quite clear. We believe that this is an issue about separation of powers, that the legislature should respect the wishes of the judiciary in its decision, both in its written decision by Justice Edens with no dissent, as well as its submitted testimony today. It's never been easier for a complaining witness to file civilly, and we thank the Office of the Prosecutor at various county prosecutors to assist individuals in filing for individuals against defendants who are charged criminally. From the Fay case, although it's in our testimony, we believe it's necessary to just read it into the record. The court said that financial obligations were not meant to prolong criminal justice oversight, creating a type of shadow control that surpasses the original sentence. The court remarked that from the outset, court monitoring of freestanding restitution orders unnecessarily burdens defendants and wastes judicial resources. We hope that the legislature respects the desire of the judiciary to not do this anymore. Thank you.
Thank you very much, Mr. Ganadin. Next, Pamela Ferguson Bray, Crime Victim Compensation Commission, State of Hawaii.
Good afternoon, Chair, Vice Chair, members. My name is Pam Ferguson-Bray. I'm the Executive Director of the Crime Victim Compensation Commission. The Commission runs a restitution recovery project that collects court-ordered restitution from inmates and parolees. We published an article with the Council of State Government describing our success in our efforts to collect from that population, which is not the subject of this, but we know a lot about restitution as a result of that project. We strongly support this provision that allows for a proof of compliance hearing. Proof of compliance hearings have been found to be an effective tool for restitution collections in the district court, and to apply that to circuit court will ensure that more victims have access to the justice that they deserve. Failure to collect restitution shifts the burden from convicted offenders to pay for crime-related expenses back to crime victims. And, you know, while there's often discussion about whether or not offenders can pay the expense of crime and that it's unfair somehow to make them pay restitution, it's equally unfair, more unfair, to have crime victims then have the burden of enforcing their own restitution orders because the court fails to do that. Over 40% of Americans can't afford an emergency expense of a few $100s, which includes our victims. So many of them, if they don't receive timely restitution, will not be able to recover from the emotional and financial impact of crime. We did a study of restitution cases out of the CJHA system from 2003 to 2018.
What's the CJHA system?
It's the Criminal Justice Database system. So we found that the mean restitution order was $303 for misdemeanors, and the mean restitution order for felonies was $1,336. So those of you who are attorneys, you know, there's a comment about, oh, it's so easy to file a civil suit. It's not easy. If you have a $303 restitution order, and you go out in this town, we know this from the victims that call us, you go out in this town and you try and hire an attorney to enforce a $303 order or an order that's a little over $1,000, you're not able to. And that's why we hear from victims, we get calls about the desperation and frustration and the violation that victims feel about the system. I think there's a quote I've included from the administrative director of the courts after a series of articles about problems and issues in the restitution system in Hawaii. Mr. Miley, clearly offenders' failure to pay restitution is a difficult, complex, and long-standing problem, but is one that absolutely has to be addressed because of the hurtful impact it has on victims, and because non-compliance with court orders undermines public trust and confidence in the justice system. We hear so much lately about the rule of law and how important that is. This is part of the rule of law, is making sure that court orders are enforced for the people who are brave enough to come forward in this system and protect us all by testifying and engaging in the system. Thank you.
Thank you very much. Finally, we have Dennis Dunn testifying in support in person.
Thank you so much again, Chair Tarnas and Vice Chair Poi Poi and members of the committee. I feel very strongly about this particular measure, and I'm testifying in support. I would ask your indulgence for me to read through my testimony, since I think it is important to provide context to the issue we're talking about here. I'm testifying in full support of this measure as it touches on the principles that are the foundation of our criminal justice system. These principles underlie the process by which we establish the dimensions of harm caused by an individual criminal act. In its simplest form, the establishment of a process of proof of compliance hearings is at the heart a direct means of requiring accountability for criminal offenders. And how do we measure this accountability? It is through the process of restitution, possibly the most critical element in demonstrating that we truly have a system that administers justice. The terms restorative justice and rehabilitation are but hollow platitudes without the full and accurate establishment of the amount of restitution, the requirement of its payment by the offender, and a meaningful process of collection. While we can tinker around with the elements of the process that this bill establishes, without basic adherence to the principles stated above, any claim that we have a fair and just system of criminal law is disingenuous and without merit. The effectiveness of our restitution process puts our feet to the fire in testing any credibility that we have in declaring that our legal process fulfills the high ideals that we so often hear loudly proclaimed when comparing our justice system to others that we consider to be inferior or corrupt. Why then is restitution so important? It is typically the only concrete measure by which we assess the harm caused by an offender. While psychological harm and traumatic emotional injury are abstract concepts, restitution measured in dollars and cents provides a means of quantification that can be understood and appreciated by both victim and offender. Restitution that is fulfilled can have a significant impact on the financial restoration of a crime victim. It is also a meaningful act that provides concrete evidence of an offender's willingness to take responsibility for their actions. Successfully competing restitution obligation is the very first step in offender rehabilitation. Failure to pay restitution, in my opinion, clearly demonstrates that an offender is not sincere about their willingness to take responsibility for their actions, nor are they serious about embarking on a path of rehabilitation. For me, restitution is the price that offender must pay to successfully re-enter civil society. So this brings us back to the bill. I'm open to ideas about how to make the process work better. I do know that in district court, we have compliance calendars that work. I think circuit court can make it happen too. We so often hear statements about restorative justice being casually thrown around. True restorative justice is focused on restoring crime victims, beginning with financial restitution, or restoration through restitution. Thank you.
Thank you very much. Is there anyone else wishing to testify on House Bill 997? If not, questions, members? Representative Shimizu.
I have a question. Is judiciary here? Judiciary is not here. Maybe I can just pose it to Attorney General. The testimony from the judiciary said that if this bill is implemented, they will need additional staff and funding to implement this.
Yes, Representative. I believe the concern from their testimony is that currently the way the bill is written, it actually goes slightly beyond what State v. Fay may have done, because State v. Fay undid a longstanding procedure that's held in district court. Circuit court, our understanding, this is not in the practice, has never been in the practice of having proof compliance hearings. And I believe the judiciary was pointing out that if this is to apply to circuit court, then that would be a new mechanism that they would then need additional resources to do. And so they were, I believe, suggesting that it be limited to district court. But we do understand that the victim advocates community may have other opinions about that.
So there may be some amendments to the bill to address that concern?
Yes, we would be open to that, and we're happy to help assist with language if the committee would like.
Okay, thank you. Thank you, Chair.
Certainly. Any other questions? One question. This is a bill from the Attorney General, correct?
It is.
Did you work with the judiciary in preparing this bill?
I can't remember at what point we began discussions with the judiciary. We have spoken with them more recently, and so we do understand their concern.
Yeah, their testimony is scathing, in a
sorry?
polite way.
Is scathing?
Yes.
Well,
They didn't want to come out, if I read between the lines, they didn't want to come out and just say, this is not workable. You know,
Oh, I believe,
there's, you know.
I believe the concern, as I indicated, the concern from their testimony is that this would apply to district court and circuit court, and
Yes.
it was never, in their view, never should have been applied to circuit court. So, and they are not incorrect. If upon a reading of the bill, it actually would apply as written to both district and circuit court.
Yes. Yeah.
So with
So-
regards to limiting it to district court, we're absolutely willing to discuss. And if there's any possible middle ground to discuss with the victim advocates community based on what their concerns are, and if that can be met as well, then we're also happy to discuss that.
Okay. I note that Senate Bill 1316 was heard and passed out of Senate Judiciary.
It did, and I believe that one, they decided to limit it to the district court.
And I think that I would really encourage the Attorney General to work with the public defenders and the judiciary to figure out language that actually complies with the Supreme Court decision instead of going beyond it. and in the words of the public defender, maybe even being contrary to it.
And I'm sorry, just a quick clarification. When I say go beyond what State v. Fay did, I mean that State v. Fay, in a practical sense, only applied to district court because district court was the only one that was already in the practice of having these proof of compliance hearings. What State v. Fay did is it said that the courts were not allowed to have these proof of compliance hearings.
Judiciary also expressed other concerns that they feel this measure, problems that this measure would cause, and they're in the process of discussing alternative options. And they think that if this bill passes, it would place significant strain on their resources and staff, and they wouldn't be able to implement it. So I think this needs more work. I appreciate that this is your effort from the Attorney General to figure out how to implement the decision that came out from the Supreme Court on State v. Fay, but it clearly needs more work. So I appreciate that you started the process. Thank you.
Thank you, Chair.
Any other questions, members? If not, let's move on to the next measure. House Bill 364 relating to animal control. This measure establishes the Spay and Neuter Special Fund to reduce pet overpopulation, including the free roaming cat population, and authorizes an income tax designation to provide revenue into the special fund. It requires that female cats over the age of 3 months and male cats over the age of 5 months be surgically sterilized with certain exceptions. It authorizes county animal control authorities to establish and enforce a permit program to allow the responsible breeding of cats, and establishes minimum requirements for breeding permits and penalties, and appropriates funds. First up, we have the Department of Taxation with comments.
Aloha, Chair, Vice Chair, and members of the committee. Garrison Kurth on behalf of the Department of Taxation. We've submitted testimony about the administration of this bill. Essentially, our involvement would be with the checkoff program option as a funding source of this program. So what that means is a taxpayer, when they're doing their taxes, could check a box if you're an individual and you have at least $5 refund coming to designate that $5 to the fund. A married couple with $10 refund could designate each $5 to go towards it. So the department has no issues administering the bill. The only request we had was that if it does move forward, we put this under the Hawaii Revised Statute Section 235, 102.5, which is where all the other checkoff options are housed. So thank you.
Thank you very much. Next, we have testimony from the Department of Land and Natural Resources.
Aloha, Chair, Vice Chair, members of the committee. Jason Omick with DLNR, and we stand by our written testimony and support. Available for questions.
You want to summarize and give us the highlights of why you think it's a good bill?
Well, for sure. In our testimony, we indicate that there's significant impact from feral free-roaming cats on the landscape and devastate our native wildlife, both through direct predation and through the spread of toxoplasmosis. I'm sure you guys have heard about this, but so free-roaming cats are known predators, and this is a serious health risk to our native species, especially the Hawaiian monk seal. So with all those things said, reducing the amount of free-roaming cats in the environment would be would really help our native species here in Hawaii.
Thank you very much. Next testimony is from the Department of Budget and Finance.
Good afternoon again. Neil Miyahara. We're offering comments. We don't think we're the appropriate department to administer this special fund. We have no expertise in this area, and we think it'll be just more efficient if you want to do this, appropriate money to the counties and let them, or another agency, to do this.
Thank you. Next, we have written testimony and support from Animal Rights Hawaii. Next, we have testimony with comments from the Hawaii Board of Veterinary Medicine.
Aloha, Chair, Vice Chair, members of the committee. My name is Carrie Shahan. I'm the Executive Officer for the Hawaii Board of Veterinary Medicine. The board appreciates the intent of this bill and offers comments. The The board is concerned that early sterilization of both male and female cats can lead to difficulty in treating lower urinary tract infections and urethral obstructions. So they would request a change to lines, let me restate that. The board would request the legislature consider amending subsection A on page 4, lines 11 to 15, by deleting paragraphs 1 and 2, and have it read as follows. A, it shall be unlawful for any person to own a cat over the age of 5 months unless the cat is surgically sterilized. The board also has some concern that this may pose a hardship on those individuals with limited income or on neighbor islands with limited veterinary care. Thank you for the opportunity to testify, and I'm here if there are any questions.
Thank you very much. Next, we have testimony from the Pacific Pet Alliance. Welcome. Please introduce yourself and proceed.
Good afternoon. My name is Lynn Muramaru, and I represent the Pacific Pet Alliance. We're a Hawaii nonprofit that promotes responsible pet ownership through education and advocacy. The Pacific Pet Alliance respectfully submits testimony for your consideration in opposition of this bill. And the reason why is that when we look at this bill, it seems like the intent is to merge 4 separate issues into one bill. And I think by the testimony that's been submitted so far or presented so far, you know, when organizations say we support or we oppose, they're only really looking at one section. For example, the different sections are the sterilization, the age of sterilization. Second one is setting up a spay-neuter fund. Third is addressing the concerns from the community and conservationists regarding free-roaming feral cats, you know, and then the last one is setting up a cat breeding permit system. Okay, so I read all 171 pieces of testimony from the earlier hearing. Okay, and a lot of testimony just says I support or I oppose, but it doesn't say which section, you know. So it's really not clear. And from looking at the overall bill, it seems like the intent is to address the free-roaming feral cat population and looking at ways to manage and control that. And so that being, if that's the intent of the bill, then what I would like to respectfully request this committee to consider is to remove the cat breeding permit, because the cat breeding permit targets the cat fancy. Okay, when I say cat fancy, I mean the people that show cats. And because I can't think of anybody who intentionally breeds just regular domestic cats.
May I ask you to summarize, Ms. Muramaru?
Okay, so so basically that's it. You know, there's already 2 Senate bills that address the spay-neuter fund. You know, we certainly agree that the conservationist aspect, the cat fancy agrees with that. We're just asking if you would consider removing the cat breeding permit section from the bill. Thank you.
Thank you very much. Next, Grant Sizemore, American Bird Conservancy on Zoom.
Aloha, Chair, Vice Chair, members of the committee. My name is Grant Sizemore. I'm speaking today on behalf of American Bird Conservancy and our members. It's nice to see a bill about cat management that has received broad support. It has earned that support because it focuses on areas of common ground among diverse stakeholders. And contrary to the previous testimony we just heard, it really focuses on the pet cat population. which is key. This bill will turn off the tap of unintended pet cat reproduction, which is essential to addressing the cat overpopulation crisis and reducing harms to Hawaii's threatened and endangered wildlife, as well as risks to public health. The management strategy that's being proposed here is highly popular among cat owners and all Hawaii residents. In fact, a recent study found that about 70% of all residents supported mandatory pet cat sterilization. Now, I understand that some submitted comments seek to authorize use of resources from the proposed spay-neuter fund to intentionally re-release cats back into the environment. And I just want to say that the conservation community would strongly oppose such an amendment, and it would unnecessarily drive a wedge into an otherwise widely supported bill. I also understand from the previous testimony that the Hawaii Board of Veterinary Medicine has requested that the age of sterilization be 5 months for both male and female cats. I fully support this change and recognize that it is consistent with recommendations endorsed by the American Veterinary Medical Association. So in closing, I strongly urge your support for House Bill 364 HD1. This bill would support responsible cat ownership and take necessary steps to address the cat overpopulation crisis. Please refer to my written testimony for additional information, and thank you for the opportunity to testify today.
Thank you, Mr. Sizemore. Next, we have written testimony and support from the Kauai Albatross Network, Hob Osterlund. Next, we have testimony and support from the Hawaiian Humane Society. Ms. Kendrick.
Chair Tarnas, members of the committee, Stephanie Kendrick with the Hawaiian Humane Society. We're proud to stand with our conservation colleagues in support of this measure. The need for better access for no and low fee spay-neuter across our state is intense, and this is an attempt to set up a statewide funding mechanism with multiple revenue sources in order to address that gap in resource availability. We do understand Budget and Finance's concerns about housing this bill, but we would urge this committee, if they are going to move it from BNF, to find another state agency where it might be housed. Simply dividing the funds by county, say by population, is not an adequate way to address the real needs, as some of our neighbor island counties, despite having lower populations, have greater needs for this sort of funding. So that's why we were encouraging a statewide decision-making body in order to allocate the funding. We would also acknowledge the conservation interests in reducing the free-roaming cat population, and while we can certainly expend any funds that this measure would raise in spaying and neutering pet cats, I have to point out that the most effective thing that we are doing right now as a community to reduce the free-roaming cat population is spaying and neutering that population. So I do think that conservation is a bit short-sighted in its opposition to allowing the use of these funds for TNR, but we will support this measure either way. Thank you.
Thank you very much. Next, we have testimony and support from the Hanalei Watershed Hui. On Zoom? Not present. Next, we have testimony from Joseph Edlund, veterinarian.
Good afternoon, Chairman, Vice Chairman. I'm a veterinarian, been a veterinarian for 45 years. I did my first spay about 50 years ago. This is a very, very complex problem, and I've looked over the bill briefly. There's some major problems with it. First off, even though I'm in support of much of the things that have been said, for example, TNR programs require 70% compliance to have any major effect on populations. Estimates of population of cats in Oahu is somewhere between 300,000 and 1 million cats, which means that we need to neuter, what is that, 70% of 300,000, we need to neuter 210,000 cats in order to have any significant effect. We do need to control the problem. I'm totally in agreement with DLNR and the need to do this, but actually it's to have a serious effect on cats on Oahu through trap-neuter release programs. And depending on the modes of funding, I know that one of the modes of funding here is going after the cat breeders. There's no cat breeders that are having any issue or any connection with the feral cat problem. This is a big, big issue. It needs big, big funding in order to take a serious stride in getting it under control. Like I say, we need to get 210,000 cats neutered. That's a lot of money to get those cats neutered and a lot of effort to make that happen. Thank you for your time.
Certainly, thank you for your time.
Open to questions, yes.
I'm sorry,
no.
what was your name?
Dr. Joseph Edlund.
Thank you, Doctor. We've received in total 69 testimonies in support, 24 in opposition, and 6 with comments. One other person said they wanted to testify, Vivian Tollner on Zoom. Not present? Okay, is there anyone else wishing to testify? If you could introduce yourself, please.
Okay. Aloha, Chair Tarnas, Vice Chair Poi Poi, and members of the committee. My name is Emily Sarasa. I'm testifying in support of HB 364 because it's a modest compromise between really different interest groups who are all trying to address the same issue. I was former president of the Student Animal Legal Defense Fund at the law school here. I wrote my thesis on the cat issue, actually, so this is a very important bill for me. If I could make any amendments to it, I would amend Section 2, subsection F, to lower the fine for violations of subsection A to only $100. I think a $500 fine is ridiculous for allowing your cat to be outside, and then also allow the fine to be waived if the cat owner can show proof of sterilization within 30 days of the violation. If possible, through this bill or maybe a resolution, I would also direct the Department of Ag to amend Chapter 4-29 of Hawaii Administrative Rules to require that cats imported to the state are sterilized before entering the state, and also, or be part of the permit program before entering the state. It doesn't make sense to have that inconsistency. Opposition from the cat breeders that are present. I think that's interesting, but we also have a backyard breeding problem here for both cats and dogs, and those people are not present. People who are breeding cats are basically breeding an invasive species, so I think the state has a vested interest in preventing that or regulating it completely. And also important to note that the new spay-neuter fund will not affect existing spay-neuter funds for TNR. So I think that any opposition to this bill is maybe also short-sighted. Thank you. I hope you support this bill, and I'll see you around.
Thank you very much for your testimony. Next, Aisha Aoki on Zoom.
Aloha, Mr. Chair and committee members. Thank you for allowing me to come and have some testimony. My name is Aisha Aoki. I am the Vice President of our Cat Fanciers of Hawaii Club, local club. Although we do support the feral population control, there are a lot of issues that we see within this bill to mirror some of the other testimonies that were here today. Our concern is that the bill doesn't truly address the feral influx. We don't see how pet populations are contributing to this. Also, with that is there's no re-release of trapped and neutered animals. So if these trapped and neutered community animals don't have any homes to go to, they're just on a track to get euthanized, because our humane society systems, our fosters, our other people who are fostering these animals are already at capacity. So it's unrealistic to say that we can't re-release these fixed animals. And I get that we have a problem of them attacking our native species. Separate from that, I myself am a cat breeder, and we are regulated by the Worldwide Cat Fanciers Association, and that is our governing body. We have catteries registered with them. We have cats registered with them. We have our litters registered with them. We have strict rules and regulations that we also need to abide by, especially for all our cats that are being shown in our shows. People are not investing their money in purchasing a purebred cat just to let them out. That's obviously not where their money wants to go if their cat gets out, gets hurt, gets killed by accident. I personally, even if it's against recommendations, I personally spay and neuter my kittens, each one before they go out, specifically so I am not contributing to our feral cat population. Many of the breeders, and there's not many, so you know, there might be a misconception that there are all these cat breeders on island or within the state. Realistically, under our Cat Fanciers Club, we only have maybe 12 to 15 breeders. So if you're expecting all these monies to come in from our breeding permits, it's not realistic.
Could you summarize, please?
Sorry. Yes. So, you know, it's unrealistic to expect, and we're responsible breeders. We have contracts, we have rules and regulations that we expect our owners to abide by. So this is just targeting responsible breeders. You're talking about the backyard breeders and irresponsible people having, you know, other litters. They're not going to follow these rules as they're not already. And they probably won't care about paying a breeder's fee, and they're going to continue going about what they're doing. So we think that this is unfairly targeting a small population of responsible breeders. And other parts of this bill do need to be reviewed. Thank you.
Thank you very much for your testimony. Is there anyone else wishing to testify on House Bill 364? And may I ask again, if you have not signed up to testify, we'll need you to go over and give your name. You can come on up now, but after your testimony, if you could give her your name and affiliation. And for anyone who's wants to testify on future bills, if you have not signed up, please go and sign up at the table over here. Please go ahead and introduce yourself.
My name is Dwayne Inoue. I'm a cat breeder. I'm a member of CFA, Cat Fanciers Hawaii. I have major concerns about this bill. As the doctor mentioned, you know, he had an estimate of what the problem is. There's no mention in this bill how many feral cats are out there, how many breeders are out there, how many hobby breeders, how many backyard breeders. I mean, there's no mention, so we don't know what the scope of the problem is. And the state has identified cat breeders, CFA cat breeders, as the ones, and there's no mention of backyard breeders, and none of the testimonies talked about backyard breeders. They're the ones that are causing the feral overpopulation. Now, please note that northern Las Vegas banned breeding. They have a penalty of $500 or $1,000 for of not following the law. They found that the animal control authorities couldn't monitor all these backyard breeders. So there's these businesses popping up that are squealing on their neighbors to get rewards. I mean, that's how bad it is, and that's the problem we're going to get. You're not going to get enough funding for backyard breeders. You're going to get only like $9,000 from CFA breeders. Therefore, I think what we need is more study, a work group of all the stakeholders, CFA, TICA, Humane Society, pet owners, breeders, and discuss what we need to do rather than shoot, like she mentioned, 4 different things and hope that it hits the wall and stays on the wall. That's mine.
Thank you, Mr. Inouye. Thank you for your testimony, which we have received. I just didn't know you were here in person to testify. Ma'am, would you like? No, he did. Okay, great. Is there anyone else wishing to testify on this measure? If not, questions, members? No. Representative Shimizu.
Thank you, Chair. I have a question for Humane Society. I heard some numbers mentioned, but do you have any estimates on the feral cat population per island?
No, we don't. We've tried a couple of different methods for getting that information and have been unsuccessful in coming up with any kind of a solid number. There are formulas that you can use based on the human population, but Hawaii's year-round breeding cycle really doesn't make those terribly applicable to our environment. So we don't have a good number for you, I'm sorry.
Right, but we can agree that that's a very big number and a major part of this discussion as far as the problem is the feral cat population.
Yes, and if these funds would be applicable to supporting TNR work, then I agree the funding needed to do that at scale would be significant.
Can I ask a follow-up, Chair?
Certainly.
Budget and Finance mentioned that they would not be able to administer this problem, suggested funding the counties. What if we were to fund Hawaiian Humane Society? Would you folks be able to take on that program?
Well, we regularly solicit funding for our TNR management program, and we'll continue to do that. But the intent of this measure is really to fund this work statewide, and we don't operate statewide as an organization.
Understand, but let's say we start on Oahu. Would you folks be able and willing to
We're
take
already
that on?
engaged in free roaming cat spay neuter on Oahu with county funding, and we have a GIA application in for the state for additional funding, which we would love your support for.
So is that a yes or no? I'm sorry.
So yes, we're engaged in this work, and we'll continue to do so.
So yes, you would be willing to take on more funding to expand that program?
Yes,
Okay,
absolutely.
Thank you. Thank you, Chair.
Certainly, thank you. Anyone else having questions? Seeing none, we'll move on. Thank you to the testifiers. Next measure, House Bill 366 relating to renewable energy. This measure requires contested cases, environmental assessment cases, or environmental impact statement cases involving renewable energy projects over 20 megawatts in size, except cases that involve any forms of incineration, to be appealed from an agency's decision directly to the Hawaii Supreme Court for final decision. It requires the cases to be prioritized and decided expeditiously. First up, we have testimony from the Office of Planning and Sustainable Development. Long time no see, sir.
Yes, good afternoon, Chair, members. Tom Eisen with the Office of Planning and Sustainable Development. We stand on our submitted testimony. It has comments acknowledging how our earlier comments were addressed in this present House Draft 1. So if you have any questions, I'm available.
Thank you very much. Next, we have testimony from the Public Utilities Commission.
Hi, good afternoon. Daniel Park on behalf of the Public Utilities Commission. We've submitted written testimony providing comments. To summarize, we've pointed out that HRS 269-1551 already provides that any final decisions and orders from contested cases before the Commission can be appealed directly to the Supreme Court for a final decision. And we've also submitted several amendments for the committee's consideration. Thank you.
Thank you very much. Next, we have received written testimony from the judiciary in opposition, from Kauai Island Utility Cooperative in support, from 350 Hawaii, Sherry Pollock in opposition, and we have received testimony with comments from Hawaiian Electric on Zoom. Not present. Next, we have testimony in writing from Ted Bolin. And finally, testimony with comments from Ona Thone, not present. Is there anyone else wishing to testify on House Bill 366? If not, questions, members? Seeing none, we'll move on. Thank you very much to the testifiers. Next measure, House Bill 992, relating to solicitation of funds from the public. This measure revises registration fee reporting and enforcement requirements for charitable fundraising platforms and platform charities with Chapter 467B HRS requirements. Removes duplication of registration fee and reporting requirements for charitable fundraising platforms and platform charities. First up, we have the Attorney General.
Good afternoon, Chair, Vice Chair, and the members of the committee. My name is Eunice Park, Deputy Attorney General, here to provide testimony in strong support of this administration bill. This bill provides housekeeping measures for Act 205, which was passed during the last legislative session, and it will also allow for easier administration of the new registration and reporting requirements for the fundraising platforms and affected entities. Thank you for the opportunity to testify, and I'm here to answer any questions you may have.
Great. Yeah, please stick around. That'd be great. I think there might be some questions. Next, we have testimony from Margaret Richardson from GoFundMe on Zoom.
Good afternoon. Thank you so much for the opportunity. I'm Margaret Richardson, Chief Corporate Affairs Officer at GoFundMe. And thank you again for having us here. GoFundMe is a trusted leader in online fundraising and charitable giving, and we enable fundraising for individuals and charitable organizations at scale with best-in-class trust and safety protections, including our industry-leading GoFundMe Giving Guarantee. In response to the devastating Lahaina wildfires in August of 2023, over $65 million was raised on GoFundMe from individuals around the world. Despite its good intentions, Act 205, as enacted, poses significant risks to charitable fundraising in Hawaii. If left unchanged, it would slow down donations, impose administrative burdens on charities and on platforms, and reduce support for Hawaii residents, especially in times of crisis. We share the goals of the Office of the Attorney General and the legislature and appreciate elements of HB 992, including eliminating the 10-day waiting period and the bonding requirements. However, based on GoFundMe's nearly 15 years of experience supporting online fundraising for individuals and nonprofit organizations, including the ongoing challenges associated with California's AB 488, we believe this bill does not go far enough to eliminate the obstacles that could unintentionally restrict charitable giving. We note that an additional bill, HB 1254, has been filed, which includes proposed remedies, including creating departmental discretion in implementation and later effective date of July 1st, 2026. Additional concerns that are not addressed in HB 992 include reporting requirements, donor data retention, and onerous written consent and vicarious liability. To address these, we support the proposed approaches within HB 1254. We're grateful to the Attorney General's office for allowing us the opportunity to convey our concerns directly with them, and we look forward to continued collaboration. We appreciate the committee's thoughtful approach to ensure Hawaii's charitable sector remains strong, transparent, and effective. Thank you for your time and consideration, and I'm happy to answer any questions.
Thank you very much. Is there anyone else wishing to testify on House Bill 992? If not, questions, members? I do have a question. You want to ask a question? You go first.
Sure. Thank you, Chair. I guess maybe this question is for Chair. Are we going to hear HB 1254?
It's not on the agenda today.
Okay. Sorry.
Question for the Attorney General. I would like your reaction to the suggested amendments from GoFundMe.
We've had meetings with GoFundMe and have discussed at length about their proposal. We did have some concerns about GoFundMe's proposal and would prefer that HB 992 be passed as is without any amendments.
Okay, thank you very much.
Thank you.
Any other questions, members? If not, let's move on to the next measure. House Bill 228, relating to license plates. This measure authorizes the counties to adopt rules for the use of electronic license plates and for intentionally obscuring a license plate with a cover or shield. It prohibits the use of license plate flipping devices and establishes minimum and maximum fines. First up, we have testimony from the Department of Transportation on Zoom. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. Larry Dill for DOT in support of this measure. These devices would potentially serve to frustrate our efforts to move forward with our safety initiatives, whereby we would capture via automated enforcement license plate information to address violators of red lights and speeding. So this would be a deterrent to our efforts to improve the safety of our system, and so we are in support of this measure. Thank you.
Thank you very much. And we've received written testimony with comments from City and County of Honolulu Department of Customer Services and from 3 individuals, 2 in opposition, 1 in support. Is there anyone here wishing to testify on House Bill 228 or on Zoom? Seeing none, questions, members? Anybody? If not, we'll move on. Thanks very much to the testifiers. Next measure, House Bill 1358, relating to the Public Land Trust Working Group. This measure appropriates monies to the Office of Hawaiian Affairs to facilitate the hiring of necessary staff and the purchase of equipment and professional services on behalf of the Public Land Trust Working Group. First up, we have Office of Hawaiian Affairs. Welcome.
Aloha,
Aloha.
Chair, Vice Chair, Representatives. Mahalo for the opportunity to come before you. My name is Stacey Ferreira. I'm the CEO of the Office of Hawaiian Affairs, and we stand strongly on our submitted testimony. If I may, just provide a few comments on our strong support. I just want to bring a notice to this body that the public land trust inventory that we have currently is based off of 1.8 million acres of land. And that inventory was done back in 1981, and it was incomplete at its inception. There continue to be ongoing gaps in our state land records. Federal and county lands are not included in the current inventory, neither are submerged lands and parcels without TMKs. So we're not truly getting the full extent of what the public land trust revenues should be. Payments to OHA have continued to fall short. In 2016, OHA commissioned audit to be done on the inventory, and at that time, in 2016, it was found that the gross receipts for public land trust revenues was $394 million, implying that OHA should have received in 2016 at least $78.9 million. And so if we fast forward to 2022, there was an increase of our payment, which was set back in 2006 at $15.1 million. It was increased to $21.5 million. So still very much short of that audit that was done back in 2016, stating that it should have been at least $78.9 million. Now, if we look forward 9 years from when that first audit was done, 9 years is a long time for a review to be done. And we are asking for that review to be done in this bill. If we were to use that $78.9 million that was called out in that audit, and we adjusted it for inflation, at minimum 2.5% annually, in 2025, OHA should be getting an annual payment of $98.2 million.
Excuse me, Ms. Ferreira, you're running out of time. If you could really focus your comments on the bill. We realize you could do a lot if you got more funding.
Correct.
And we haven't been providing that.
And so I guess the impetus of me sharing the disparity of why we need this audit is because it has been incomplete. It has not, an audit has not been done by this body, by the legislature. And for us ever to be able to see the full 20% that is required by law, we need this inventory to be done. Mahalo.
Yeah, thank you. I didn't mean to cut you off. I just wanted to help the committee understand why this particular bill was important
Yes,
to do
mahalo.
what it does. Okay, thank you very much. Next, we have Department of Land and Natural Resources.
Good afternoon, Chair, members of the committee, Ian Hirokawa with DLNR. We'll just stand on our written testimony in support of the measure and also offering comments and be available for any questions. Thank you.
Ian, remember, we gotta give us the highlights.
Oh, I mean, I think we just support the work of the Public Land Trust Working Group. And, again, we just want to stress, though, that with regards to the PLTIS and that's
The what?
mentioned. I'm sorry, the Public Land Trust Information System, which is the computerized database, that was created. We rely on data and information provided by what we'll call the agencies that manage those specific lands. So we would just say if there are discrepancies or errors that come up, that I think we say that, OHA, we would want them to work with those agencies to correct any discrepancies. We're just collecting the data and putting it into the system.
Thank you very much.
Thank you.
Mr. Hirakawa.
Thank you.
Next, we have testimony we received from numerous individuals. The total count is, we've got 44 testimonies in support and 2 in opposition. And the next person that said they want to testify is Kimmer Horson. Not present. Next, we have, the next person said they want to testify is Jermaine Myers on Zoom, not present. Next person, Cavallo White, Mr. Guerin or Ms. Guerin, not present. Next, Sherry Broder. Please proceed.
Good afternoon, Chair, Vice Chair, and committee members. I was appointed by the Office of Hawaiian Affairs as a member of the Public Land Trust Working Group, and I have, throughout my professional career, helped and worked for the Office of Hawaiian Affairs. I was actually the attorney at the 1978 CONCON to draft the provisions in Article 12 that created OHA. I have been involved many times over the years in efforts to make an accurate and complete inventory, the efforts to have an accurate and complete reporting in Act 178. This is a very good working group that has been created, and I'm optimistic that we may be able to actually come to a conclusion. We did do a long report. In my testimony, I gave you the link to the report that was filed in the legislature. So we did a joint report, the OHA reps and the state members. We drafted an OHA supplement because I wanted to collect all the information from over the years about what the issues are and what the problems are and everything from OHA's point of view, so that it would be in one place. But out of respect to the state members, I thought that OHA could do its own at this stage. I think it's really critical that we get the funding to be able to do this kind of an analysis. As the DLNR rep pointed out today, the DLNR relies on the agencies for reporting, both on the lands and whether or not they're in the public land trust, and on the revenues that the agencies are giving. DLNR doesn't have the resources to be able to check the information. The state agencies don't necessarily have the expertise on staff to do abstracting like DLNR does. They have the ability to abstract property. So I think that what we need is a third-party independent, so nobody says, oh, it's OHA or it's the state. And I think it's really important, not just for Native Hawaiian people to have complete and accurate inventory and complete and accurate revenue reporting, but it's also important for the general public. I mean, we should have a complete and accurate inventory. So that is not to say anything about the current public land trust information system. But if you do go to the website, you will see a long list of caveats of issues that are issues relating to the inventory that we do have. I'm available for any questions.
Thank you very much, Ms. Broder. Thanks for your good work.
Oh, thank you.
Is there anyone else who wishes to testify on HB 1358? If not, questions, members? Seeing none, thank you very much. And the testimony from Ms. Broder is very informative. I would urge members to read that and check on the references that are in the testimony and additional resources. I appreciate the work you put into that. And thank you to the Office of Hawaiian Affairs for your work to facilitate the working group and move that forward. It's very important work, and to DLNR for doing your best effort to try to make sure that information is accurate. We have a long way to go, and we have to deal with this issue. Very important. Okay, let's move on. House Bill 1007 relating to the Hawaii Community Development Authority. This authorizes the Hawaii Community Development Authority to cooperate with or assist public and private sector entities to engage in projects that improve the state. The measure establishes the transit-oriented development infrastructure improvement program under the Hawaii Community Development Authority and repeals the transit-oriented development infrastructure improvement district and board. First up, we have Office of Planning and Sustainable Development. Mary Alice, please come on up to the rostrum since everybody wants to see you in TV land, and if you could summarize your testimony.
I will summarize. Thank you very much,
After you introduce yourself to everyone so they know who you're a famous person, but not everyone knows you.
I am Mary Alice Evans, the Director of the Office of Planning and Sustainable Development, attached for administrative purposes to the Department of Business, Economic Development, and Tourism. We stand on our testimony in strong support of this measure. I am the co-chair of the TOD Council, which was created by this legislature.
TOD means?
Means Transit-Oriented Development Council.
Thank you.
And we see this measure as making transit-oriented development much more attainable, and we strongly urge you to support it.
And if you could really briefly, for those who don't know, transit-oriented development, just briefly, you're a good planner and you know you can explain it really briefly in lay terms.
Transit-oriented development is locating mixed-use, mixed-income communities with slightly higher densities around rail stations, transit hubs, and bus corridors, both on Oahu and the neighbor islands, to allow people housing with other community services and transit choices. That will help avoid locating sprawling subdivisions in our best ag land, although I do support housing in marginal ag land.
But TOD, I just wanted you to explain what TOD, transit-oriented development, means. This is a good educational opportunity for our members and the public, so I wanted to avail myself of your expertise.
Thank you, Chair.
Thank you, Ms. Evans. Next, we have testimony support from the Department of Business, Economic Development, and Tourism. Next, we have testimony with comments from the Department of Land and Natural Resources. Mr. Hirokawa.
Good afternoon, Chair, members of the committee. Ian Hirokawa with DLNR. We're offering comments. What we're asking is just a minor amendment to page 21, lines 8 and 9, just to delete the phrase including property already devoted to a public use. That's in the condemnation statute. We're just concerned that that phrase could, if read broadly, could imply that the HCDA would be able to condemn other government lands, so lands under DLNR or set aside to another agency. So we just would request that phrase be deleted.
Thank you. And when you refer to HCDA, that's the Hawaii Community Development Authority.
Yes, thank you.
Yes.
Thank you, yes.
Thank you. Thank you very much, Mr. Hirokawa. And now we get to hear from the Hawaii Community Development Authority.
Thank you very much. I'm not as famous as my colleague Mary Alice Evans, so I will introduce myself. I am Craig Nakamoto. I'm the Executive Director of the Hawaii Community Development Authority. Chair Tarnas, Vice Chair Poipoi, and members of the committee. This is our administration bill, and this bill is very important to us. So I'm going to take a little bit of time to kind of explain why we're doing this, and I'm going to be open to questions. So the bill is really in two parts. The first part is to allow the Hawaii Community Development Authority to assist other state and county and private sector entities with projects. And these would be projects that go beyond our community development districts. The Hawaii Community Development Authority has been in existence, especially in Kaka'ako, for almost 50 years. Since 1976. And through that time, the staff and others have amassed a lot of expertise and experience in developing infrastructure. And so our board has authorized us to go out and use that expertise to help other state agencies, assist other state agencies. And we've done so helping the Department of Corrections and Rehabilitations with their kitchen build at the Women's Correctional Facility. We worked with DLNR, Mr. Hirokawa and Mr. Tsuji.
The Department of Land and Natural Resources.
Department of Land and Natural Resources on a feasibility and market study for Waiakea Peninsula, also known as Banyan Drive. So the changes to our findings and purposes section, it really kind of reflects the evolution of the responsibilities and roles of the agency to current. And by just making those changes, we'll be able to help other state public sector agencies and the private sector. And I think it adds to government efficiency as well by us being able to use our expertise for that purpose.
Great. Thank you very much, sir.
Okay, second part, and I'm open for questions on this. As Ms. Evans stated, so we have a transit-oriented development improvement district in our statute. This was created in the 2022 legislature to direct us to build transit-oriented development infrastructure in TOD areas. It came with 4 county boards. This is in addition to the 5 boards that we currently have, so we would have a total of 9 boards. So the 2 reasons why we're asking to remove these boards is, one, because of the existence of OPSD that does the planning, the existence of the Transit-Oriented Development Interagency Council that prioritizes TOD projects, there's a lot of community engagement and a lot of community representation on the TOD Interagency Council as it is. So we don't see the need to have 4 county boards as well. It seems redundant. I think the second reason is, as I mentioned, these 4 county boards would really add to our 5 boards that we have now, and I think removing them would administratively simplify the burdens attached to that program by making it a program, and it would report up to the General Authority Board, which is 17 members. Okay. The other change we made, and I'm open for questions on this, is with respect to the assessments against real property. So this was kind of a relic of what we have existing, and we took it, I think, in 2022 to insert it into this bill. What the changes we've made, Chair and Vice Chair and members of the committee, is to change it to a user service fee to kind of take this away from a kind of a lien on real property, these cost sharing, take it away from a lien on real property and take it away from like an assessment, so as to not make it like a tax on real property, which we don't have the authority to do. So we've changed it to a user service fee, but the purpose is the same. Sometimes when we have improvement district projects that, let's say it's to improve a sewer on a specific street, these are off-site infrastructure improvements, and we would seek in some cases to proportionally sort of establish fees for benefiting landowners along that street. And we would follow the same sort of procedure we do with any kind of improvement project. We'd identify the project, we'd estimate the cost, we'd see what landowners were benefited and not benefited, and then we would establish these user fees. Typically, we've done those through rulemaking when we did it for Kaka'ako, and we could do it a similar way for this. But again, we just tried to move this away from that lien on real property and avoiding making this look like a sort of a tax on real property. And then the other part of the bill just clarifies our condemnation, that we have condemnation powers for this part of it, which are important, but of course, in my mind, needs to be exercised very judiciously at all times and as a last resort. So I'm open for questions.
Please stick around. That'd be great.
Okay.
Thank you,
Thank
Mr.
you.
Nakamoto.
Thank you.
We've received written testimony from the Oahu Metropolitan Planning Organization in support and 2 individuals, 1 in support, 1 in opposition. Is there anyone else here wishing to testify on House Bill 1007? If not, questions, members? I do have oh yes, please go ahead, Representative Belatti.
I have numerous questions, I think, for Mr. Nakamoto, but I'll try to refrain.
Go ahead.
But this is complicated, and this kind of rushed through Waterland, which I was sitting on, but we just didn't have enough time to dig into it. I guess the first thing is for the condemnation around transit-oriented development areas. Are there specific projects already in mind that are prompting this clarification of the law?
Representative Belatti, the answer is no. The answer is no. Because we had to come in to make some changes to the boards and remove the boards to a program kind of structure, we just thought it might be good to just clarify that we have this condemnation powers under this section of our statutory framework. But we do not have any, right now, projects where we're contemplating condemnation.
Okay, for the areas that are TOD, I mean, I'm thinking of places like where rail is coming through town. And can you conceive of any places that that there might be a request from a private entity where you're in a public partnership or something and that you would ask for that authority
For condemnation?
for condemnation?
Well, I can think.
Let me back up.
Oh, sorry.
These TOD zones are contemplated for the rail line, correct?
They are.
And then how
on the
far,
path.
what is the range around the
I think it's a half-mile radius generally.
okay, so as rail is coming through, I'm thinking, especially in urban Honolulu, do the areas of Kaka'ako Makai fall into that TOD arena so that this could have impact on bills moving on regarding Kaka'ako Makai?
Currently, let's see. Yeah, so the closest station to Makai around that half-mile radius is the station that's at Halekauila. So it's Kaka'ako station. So when you count half-mile, it just barely touches on Makai.
And then there's a rail station also nearby Aloha Tower.
Correct, but
area.
that, yeah.
And then there's also going to be an area going through the Iwalei area.
Correct.
So we're talking about large tracts of very potentially important lands for development.
Correct.
And I know that you're saying you're just coming in and maybe clarifying things, but this is actually quite a broad expansion of your powers
So
around very important lands.
So Representative Belatti, let me again just clarify. When this section of our statute was first examined in the 2022 legislative session, there were questions about what our powers were going to be, because I think the same questions that you're raising now were brought up in 2022. And this section of our statute directs us to do infrastructure kind of work. It is not intended to be vertical construction. It's not intended to be vertical construction, but the same thoughts that you have and the same concerns you have came up. So where we might use condemnation, Representative Belatti, just again for an example, is if someone asked if we had to do a roadway, reconstruct a roadway or do roadway improvements, and the right-of-way needed to be a little bit wider to meet current county standards, there is a possibility that we may need to condemn certain parts to achieve that roadway width. But again, this is really for infrastructure development, not for vertical. But it was the same concerns that were brought up in 2022, so I think we address it in the statute that this is for infrastructure only.
Please go ahead. Your questions are very informative, so please help us out. Go ahead.
I think we might want to relook at that because I don't know if it's as limited as you say it is, as it may be fleshed out. But again, this is like only my second look at this.
Well, Representative Belatti, I'm willing to entertain further amendments to 206E and this part to say that the work we're going to do under here is for infrastructure only, if that gives you assurances. I think it's stated elsewhere, but I'm happy to provide some language to the chair, vice chair, and either point out that it's there or provide that assurances, because like I said, Representative, this bill is important to me and the agency, and I want to see this go through this time.
Thank you, Mr. Nakamoto. Maybe one more question.
Certainly.
And this is sort of connected, and it's, again, we're looking at this in pieces, right? So when you talk about the section that has assessments against properties, and you're shifting it from property liens to user service fees. Can you explain what that is? Because as I look at those areas that you're talking about, there have been beneficiaries of those infrastructure developments, or there may be beneficiaries. Who's the user that's being charged or contemplated in this, where this language is being changed?
So it's a good question. I'm going to try to explain it in the context of, a sewer line that goes down Main Street of a place, and it's an upgrade to maybe a bigger sewer line, and there's maybe 20 potentially benefiting, landowners, right, that would benefit from that off-site development. So we would probably do rulemaking and public hearings to, say that we're going to assess or, charge a service fee, and then we would charge it or establish it against benefiting landowners. So as an example, if and they have to be benefiting. So if one of the landowners didn't benefit from that particular, project that we did, they wouldn't be a benefiting landowner, and therefore we wouldn't proportionally charge them a service fee. One other example is, maybe there's a established building on one of the parcels, and they don't benefit by the, sewer upgrade. Then we might not consider them a benefiting landowner. On the other hand, a fully developed parcel with a building on it, if we did street, sidewalk, gutter, curb, and maybe drainage improvements, that same, fully developed condominium might benefit from that. So we may deem that a benefiting landowner and charge a fee. And I think the question you're going to ask next is who's ultimately going to pay for that? So off-site infrastructure in the case of a parcel that's not yet developed yet, not that developed, I shouldn't say not that developed yet, but not developed, the developer could take that cost. Let's say the cost to that developer is $100,000. The developer could take that cost and could include it in the development cost, and then it would sort of be part of the total development cost for that project. Okay. Or the developer could, I think, apportion that cost out to individual unit owners. I think either way, Representative Belatti, these off-site infrastructure improvements that help a parcel or benefit a parcel, I think in some way, and I think it's unavoidable, it's going to end up impacting something with that project, because if that 100,000 goes into the development cost, I think it'll affect the, per unit cost of those units. So it'll affect the buyer. If it doesn't get passed on that way, and it goes to be passed on as part of the HOA fees, as an example, it's still going to go to the cost of home ownership, right? And it goes along with HOA, other HOA fees, maintenance fees, property insurance, mortgage, all those things. So I just want to tell you that I have no other way to explain this, and I want to tell you that that is how it might go.
Well, I think that's actually a really good explanation, because we did not get that explanation in the Waterland Committee. And I guess the question is, you have building A that comes in year 1, and you have building 2 that comes in year 3. How do you portion the cost in a fair manner? And frankly, what I'm really concerned about are the luxury developments that are probably going to go up in this valuable real estate, and we're going to be paying the cost versus those individuals who, if it ends up looking like a lot of what Kakako looks like, frankly, they should be paying for the infrastructure.
Well, and
how do we ensure that?
Okay, so the first step is we identify a project, sewer, and then we identify benefiting landowners, and then we would apportion that cost, the cost of it, a portion of the cost, not the whole thing, but a portion of the cost. And we would base it based on frontage area or parcel size. The denominator being all of the square feet of the parcels on that street, and then the numerator would be benefiting parcels. So that's how we would do it, and it would be something that the landowner would have to pay. So whether a parcel came up for development, parcel A, at year 1, year 2, or year 3, it would still be a service charge or a user fee on that parcel. And I think this is we've done some of these ID projects in Kakako, what we call improvement district projects, where there has been an assessment. And to your point, Representative, this way of cost sharing kind of passes on some of the cost of off-site infrastructure to projects that benefit along the street, whether they be luxury projects, as you say, but it also could be affordable, homes projects, affordable projects, to be honest. It would be whether they benefit.
Thank you. This is a really complex, and I'm surprised that more people are not weighing in, given the areas that you are going to be touching. But thank you, Chair, for indulging in my question.
Yeah, but Representative, if you want, I'll go back and with the Chair's indulgence, I'll look back and I'll look for language in the statute. And if it's not clear already, we can clarify that it's really infrastructure only, just to give you assurances. But I want to see this bill passed, so.
Thank you.
Thank you, Chair.
Thank you, certainly. Any other questions, members? Representative Shimizu.
Thank you. Question. Thank you, Chair. Question. So, the fee is not a one-time fee; it's an annual fee. Is that what I heard?
So it is a one-time fee that's going to cover their proportionate cost of the improvements, and it could be paid over time. It could be paid over time.
So, related to Representative Baladi's question, if the owner changes and they upgrade the use, how does that fee get adjusted up accordingly?
It doesn't necessarily get upgraded or changed, because I think once we set that user fee is attributable to the land, and that is the fee that's going to get paid. It doesn't get increased just because the use gets increased. It's because it's for the proportionate cost of a part of the infrastructure improvements.
Yeah, I guess maybe the thought is maybe it should be adjusted because the benefit is profiting a user that taxpayers invested in. So it should increase accordingly, maybe?
I think I would counsel against that, Representative Shimizu, because I think what we're saying is there's a cost, let's say 1 million of putting in this sewer. And at that point in time, that is the cost. And proportionally, it's going to be, divvied up among the benefiting landowners. If we were to try to increase that cost over time, I think we'd have to go out and, have people buy in again to it, or we'd have to go out with some kind of, public hearings and get that approved.
I follow you. Chair, can I get one more question?
Yes.
So the current transit-oriented development infrastructure improvement district board is currently under the HCDA. Is that correct?
It is.
So just because I'm simple-minded, I'm just wondering, when you replace that and you establish this new transit-oriented development infrastructure program, is that like a total staff change and everything, or is it just implementing a broader scope as was discussed?
So, Representative Shimizu, it's a good question, because the structure that within HCDA is often not easy to understand. So it does not change the staffing or anything. It doesn't affect that. What we're asking for really is a structural change in the board so that we really replace the 4 county boards, which haven't been really constituted, and replace it with the existing 17-member at-large board. They're going to have governance over this program.
Okay, thanks for explaining that. That makes it clearer. Thank you, Chair.
Thank you very much. Other questions, members? Just a brief question for you.
Yep.
On your testimony, third paragraph, first page, the very end of it, it says, given the evolution of the HCDA's responsibilities, this section should be revised to reflect the current responsibilities and roles of the HCDA. Does that mean that you want to make additional revisions than what are in the bill?
Sorry, no.
Or
no.
that this bill makes the revisions that you want to make?
This bill makes the revisions we want to make.
Just wanted to make
In
sure.
the findings and purposes.
Okay,
And,
thank you.
And Chair, also, I heard the testimony of Mr. Hirakawa and Ms. Evans, and we agree with the changes that they have suggested to the bill.
Perfect. Thank you. Appreciate that. You thought of my next question.
Okay, thank you.
Okay, thank you. Any other questions, members? If not, we'll move on to the next measure. Thank you to the testifiers. As you noticed, members, we added some additional measures. First up, HB 958 relating to transportation. This measure requires all bicycles equipped with motors to be operated only with all wheels on the ground at all times with certain exceptions, prohibits certain actions while operating a bicycle equipped with a motor, prohibits the operation of high-speed electric devices in certain locations, requires manufacturers and distributors to apply a label to electric bicycles, requires distributors to place a sign at or near the point of sale regarding electric bicycles, defines electric bicycles in place of low-speed electric bicycle, defines electric micro-mobility device, and requires the same regulations of electric foot scooters to apply to electric micro-mobility devices. And it goes on. I'm not going to read the rest of it, but that it's I want to thank our transportation chair for working on this measure, and it came to us from transportation. So let's hear testimony on it. First up, we have City and County of Honolulu Department of Transportation Services and Support. Next, we have testimony with comments from one individual, testimony with opposition from another individual, and testimony and support from another individual. We've got all sides. Is there anyone else wishing to testify on House Bill 958? If not, we'll move
Yes,
on.
Chair, Department of Transportation.
Oh, there you are. Please proceed.
Yes, I thought we got written testimony submitted, but perhaps not. But at any rate, Larry Dill with the Department of Transportation. Aloha Chair, Vice Chair, members of the committee. We are in support of this bill. Generally speaking, this bill addresses a burgeoning industry in Hawaii with the growth of many very different types of electric bicycles and electric e-mobility devices. It brings some definition and clarity to an area to address what we consider what are, at the end of the day, vulnerable road users using our public rights-of-way. And this will assist significantly in being able to provide definition about how those various types of devices are able to be used in the right-of-way and under what kind of conditions, generally speaking. Thank you for the opportunity to provide this testimony.
Thank you very much. Sorry, your testimony came in late and I overlooked it. I apologize. Thank you, Mr. Dill. Anyone else wishing to testify on HB 958? If not, questions, members? If not, thank you very much to the testifiers. Let's move on to the next measure, House Bill 604, relating to tax revenues. Beginning on January 1st, 2026, this measure increases transient accommodations tax rates by 1 percentage point and deposits the increased revenues into the Hawaiian Home General Loan Fund established under the Hawaiian Homes Commission Act 1920 as amended. First up, we have the Hawaii Tourism Authority. And not present. Next, we have Department of Taxation. Please proceed.
Aloha again, the Garrison Kurth on behalf of the Department of Taxation. Essentially this bill, we've submitted testimony we stand on, but essentially this bill, as you said, increases the transient accommodations tax by 1%, raising it to 11.25%. Of that, 9.25% of that continues to be deposited as it is today.
Another 1% continues to go into the mass transit fund as it is today, and the extra 1% will go into this Hawaiian Home General Loan Fund. The department's role is to collect those revenues and make sure they're deposited correctly. We have no problems and can administer this bill as written. We just request that if it is passed, it's amended to January 1st, 2026 for the effective date so we can make the changes we need to. Thank you.
Thank you very much. Next, Department of Hawaiian Homelands. Director Watson, thanks for your patience. Please proceed.
Good afternoon, Chairman Tarnas and Vice Chair Poi Poi and members of the committee. I'm Kali Watson, Department of Hawaiian Homelands. We're in strong support of this particular bill. Similar to House Bill 606, it provides a source of funding that we need in order to do or address the people on our waiting list. This obviously would generate, in addition to 606, significant sums, but on a regular basis rather than a one-shot deal. So we're excited about this bill, and we strongly support it.
Thank you very much. We've received written testimony in opposition from Kohala Coast Resort Association. Written testimony in opposition from Grassroot Institute of Hawaii. Written testimony in opposition from an individual, and also comments from the Tax Foundation of Hawaii. Tom Yamachika on Zoom, not present. Anyone else wishing to testify on House Bill 604? If not, questions, members? Just one, would the Department of Taxation be able to give us an estimate as to how much this might generate?
I don't have a formal estimate at this point. I mean, I know I looked at the fiscal year 2024, the tax collections or the transient accommodation tax collections were $828.3 million, so 1% would be $8.3 million, so that probably gives you a rough idea. I understand it's a little more complicated than that, and they reverse math it just to take account for some nuances in there, but that should give you some rough idea.
So again, the number would be approximately?
8.3.
8.3 million.
Right.
Okay, great. Just an idea for the committee to consider. Okay. It's something. It's not the 200 million that the Department of Hawaiian Homelands has requested, but it's something. Okay. Is there any other question? Seeing none, let's move on. Thank you very much to the testifiers. Next, the last bill on the agenda, House Bill 1308, relating to sports wagering. This measure allows for the regulation of sports wagering by the Department of Commerce and Consumer Affairs. It establishes licensing requirements for sports wagering operators and sports wagering suppliers, and specifies that sports wagering and fantasy sports contests shall not be considered contests of chance or gambling. First up, we have Department of Commerce and Consumer Affairs.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Nadine Ando. I'm the Director of the Department of Commerce and Consumer Affairs. We stand on our written testimony opposing this bill for a number of things that we are noting in the testimony. I'm just going to sum it up very briefly. You know, it's the fact that, number one, that it's puts us in the position to have to be regulating sports wagering, and it basically is something that, you know, we believe it's somewhat contrary to what our mission is, which is to protect consumers and promote fair competition and foster a healthy and vibrant business environment in Hawaii. And although we do regulate a number of industries or professions, introduction of something like regulating sports wagering presents very unique challenges for our department and may conflict with our existing mandate. So we don't believe we're suited to be regulating this operation. And the concerns are that, you know, sports wagering by its nature, we believe, carries some inherent risks for consumers, including the potential for gambling addiction and financial hardship and related social issues. So while we recognize this is introduced in part to address illegal gambling markets in the sports wagering area and generate some tax revenue, we believe basically the concerns outweigh the benefits. And so lastly, if the committee is inclined to move forward with this bill, we believe it would be appropriate for the committee to refer the matter to the state auditor for a sunrise analysis. pursuant to HRS Section 26H-6, and request that the bill be deferred until such an analysis be done.
Thank you very much. Next, we have testimony from the Attorney General.
Good afternoon, Chair Tarnas, Vice Chair Poi Poi, and members of the committee. My name is David Williams. I'm a Deputy Attorney General. I work in the Criminal Justice Division. The department respectfully opposes this bill because it's concerned that legalized gambling in the form of sports wagering conducted by business corporations or other money-making enterprises on a large scale in Hawaii will increase the risk of adverse financial effects on Hawaii citizens. And as noted in our written testimony, studies have shown that legalized gambling has resulted in increased bankruptcy, negative effects on the family, and even domestic violence, especially in families from the most vulnerable economic households. However, if the committee advances the bill, we did offer comments regarding the penalty section, page 26, as it currently does not comport with the authorized terms of imprisonment in the Penal Code, Hawaii Revised Statutes, section 706-663 and 706-660. And the department included in its testimony suggested wording to address the issue and make it a misdemeanor as a first offense, Class C felony as a second offense, and a Class B felony for a third offense. Thank you for accepting our testimony. I'll be available for questions.
Thank you very much. And next, Department of Taxation.
Good afternoon, Chair Tarnas, Vice Chair Poi Poi. My name is Winston Wong. I'm the Administrative Rules Officer at the Department of Taxation. The Department of Taxes has submitted written testimony on this bill, which establishes a framework for legalized sports wagering in Hawaii. The DOE tax has provided comments specifically on the tax aspects of this bill, as you might assume. What this bill does is it imposes a general excise tax on sports wagering receipts at 10%. The department has a few issues in this bill that we've noted in our testimony that I'll highlight for the public. First, DOE tax requests clarification that the agency tasked with collecting the tax on sports wagering in Section 11. Currently, it simply refers to the department, but department is defined in this bill as the Department of Commerce and Consumer Affairs. So if DOE tax is to administer this tax, as it does with most general excise taxes, then we ask that it is specified within this section that the Department of Tax is the appropriate department. Second, the Department of Tax also notes that there's going to be a difficulty in the proposed allocation of general excise tax funds specifically from sports wagering revenues as contemplated in this bill. What happens when a taxpayer pays their general excise tax bill? They don't specify exactly what the source of those funds or what the source of that liability is from. If, for instance, one of the online sports wagering companies has merchandise that they sell or subscriptions or any other type of revenue, they would also be subject to general excise tax, and they would pay that all with one payment. The department isn't equipped to process that and sort it out into the various special funds. If the committee and the legislature do intend for specific sports wagering receipts to be allocated to certain special funds, then the alternate solution to that is to establish a separate sports wagering tax, similar as to what's done with the cannabis bills, where it was proposed that there'd be a cannabis tax that was set up. That would be a little bit easier for us to administer in terms of just allocating those revenues specifically to special funds instead of the general fund for this, and specific revenues from sports wagering onto another fund. And the alternative, we also ask that, just for simplicity, if that's not workable, then the legislature just set a set amount of appropriations for the specific funds. Third and finally, the department just asked for clarification on whether or not the 10% GET rate discussed in this bill and how it applies to sports wagering suppliers. Sports wagering suppliers, as defined in this bill, are those who provide software and systems to those who are operators. They're not authorized to accept wagers, so it's unclear as to how they would really be accepting any sports wagers and subject to the tax provisions of this bill. So if they're not intended to be subject to that GET rate, then please remove them, but if they are, then we just ask for clarification on how that would be possible. I'm available for any questions you have. Thank you.
Thank you very much. Appreciate your testimony. Next, we have testimony and support from two representatives of BET MGM. If we could have just one of them providing testimony, if that's appropriate. Jeremy Limham or Richard Taylor on Zoom. Please proceed.
Did you want to do it, Richard? You can go ahead.
Yep, I'll take it. Good afternoon, Chair, Vice Chair, and members of the committee. For the record, my name is Richard Taylor, and I serve as the Director of Responsible Gambling for BetMGM. I'm here today in support of HB 1308 and to highlight BetMGM's commitment to responsible gambling. I've submitted written testimony, so I won't rehash that, but I would like to highlight a few areas of my testimony. First, each year, billions of dollars are wagered on unregulated sites, exposing minors and vulnerable individuals to unsafe gambling. Legalizing online sports betting in Hawaii would provide a safer, regulated alternative, ensuring consumer protections while generating tax revenue for the state. At BetMGM, responsible gambling is at the core of our operations. We offer an array of player tools like deposit limits, loss limits, and the ability to take temporary and permanent breaks from play. We also provide game sense information, which is designed to help drive self-awareness and informed decision-making amongst our players. Finally, we are proud to partner with Kindbridge Behavioral Health, a telehealth provider that specializes in treating problem gambling. They provide players who self-exclude due to problem gambling related issues with care and treatment at no cost. Legalization presents an opportunity for Hawaii to introduce consumer protections and safety nets, many of which are not offered within the illegal market. I appreciate your consideration and urge your support of HB 1308. I want to thank you and I welcome any questions that you may have. And finally, I just want to call out that I appreciate the problem gambling treatment and promotion aspects of the bill. I think having these in the bill are essential and will help to ensure that the safety nets and guardrails that are needed when you introduce legalized gambling can be created. Thank you for your time.
Thank you very much. Next, we have testimony on Zoom from Rebecca London with DraftKings. Please proceed.
Good afternoon, Chair and Vice Chair. My name is Rebecca London. I'm a Senior Government Affairs Manager for DraftKings, and I'm here to provide testimony today in support of HB 1308. I appreciate the opportunity to testify today and to continue this conversation about the importance of Hawaii embracing a competitive, fully mobile sports wagering market. DraftKings is a digital sports entertainment and gaming company launched in 2012, and DraftKings Sportsbook is live with mobile and/or retail sports betting operations pursuant to a regulatory framework in 28 states, Washington, D.C., and Ontario, Canada. DraftKings is committed to being a responsible steward of the new era in real money gaming by developing and promoting education, information, and tools to help all players enjoy our games responsibly. As my colleague at MGM noticed, it's important to recognize that sports wagering is already taking place in Hawaii with an estimated hundreds of millions in illegal wagers each year. Nearly all the sports wagers in Hawaii are placed online through websites in the robust illegal market where sophisticated illegal operators capitalize on the popularity of this form of entertainment. Across the country, states are bringing this activity into a legal, regulated market that mandates robust consumer protections. To date, 33 jurisdictions have authorized mobile sports wagering, allowing customers to place bets conveniently from their mobile phones and other devices. In a well-regulated market, consumers benefit from a variety of competitive and innovative products, as well as a robust problem gaming resources and consumer protections offered by these regulated companies that are not available in illegal markets. I've submitted further written comments, which I stand on, and I welcome any questions you may have. Thank you again for your time today.
Thank you very much. Next, we have testimony in opposition from Noella von Weigand, not present. Next, we have testimony from Dwayne Batista. Please proceed.
Hello, Chair, Vice Chair. My name is Cody Sula with the Ironworkers Stabilization Fund. Dwayne Bautista couldn't be here today, so I'll take up his time. But thank you for your opportunity to testify today on this bill. The Ironworkers Stabilization Fund is in support of this bill. And Why is a construction union here to support sports wagering? We believe it's a good first step to diversify the economy. It's one of the biggest conversations that's been had over the last decades about how can we diversify the economy in Hawaii, keep our people home. Since 2016, we had about 16, since 2016, we've had a population drop over since that time. Also, with the newest Alice report that came out, they're saying about 180,000 residents are currently considering relocation. That's because of the high cost of living, the lack of affordable housing, and it's impacting people here. People are struggling. We know that sports wagering can be a hot topic, but it's happening. It's all over our communities. Everybody has a phone here. Everybody here can be, betting illegally right now. So we believe that the framework is good to keep the conversation going. We understand that it is a complex topic, but the biggest thing that we got to remember is that we have people leaving our islands. They're moving to Vegas. They're moving to Arizona, Texas, wherever. And half of our money goes out to Vegas anyway. People going, it's not going to change. People want to gamble, they're going to go to Vegas. But our main issue is we want to make sure that we come up with innovative ways to help bring relief to our people. Because we talked about, I'm going to wrap it up right now. We're talking about in the newspaper, they said that tourism's not bouncing back like they thought it would after COVID. Talked about the school lunches for the kids is going up to $9. Where they're going to get the money to fund, to pay for the kids' lunch. All these issues, and the money from that tax revenue can go back to help fund those programs so we can bring relief to our people. So the iron workers are in support of any type of bill that's going to bring new revenue into the state. Thank you.
Thank you. So you're representing Iron Workers Stabilization Fund?
Correct.
Great. Thanks very much for the record. I appreciate that.
Thank you.
Next, we have testimony in support from Mel Kahele. Not here, okay. Is there anyone else wishing to testify on House Bill 1308? Please, come on up, introduce yourself.
Aloha, Chair Taunus, Vice Chair Poi Poi, and members of the committee. I'm Christine Denton, Special Counsel to the Prosecuting Attorney for the City and County of Honolulu, and I'm testifying on behalf. I did submit testimony, and she said that you had it, but I'll just sum it up really quick. We strongly oppose.
Oh, yes, I'm sorry, we do have it. I didn't realize you were going to be here in person. That's why I didn't call you.
I'm sorry.
No worries. Please proceed,
did
Ms.
sign it.
Denton.
Thank you. We strongly oppose this bill. Our current gambling laws allow for social gambling like poker night, Super Bowl betting pools, and in this manner, sports wagering can already be enjoyed legally by Hawaii residents. However, once gambling starts to involve large-scale operations, especially online sports wagering, there are many societal costs that are associated with it. In a July 2024 study, researchers found that the ease of access to sports gambling online is harming consumer financial health by increasing their level of debt. This study found that there were 25 to 30% more likelihood of bankruptcy filings, as well as an increase in auto loan and credit card delinquencies and collections. This bill offers that ease of access that contributes to the exasperation of gambling-related financial harm, because citizens will be able to place bets anytime or anywhere as long as they have a smartphone. In addition to financial issues, legalized sports wagering increases intimate partner violence. An August 2024 study found that when sports gambling is legalized, the effect of the NFL home team upset losses on intimate partner violence increases by around 10 percentage points. With so many issues facing our state, affordable housing, homelessness, drug and alcohol addiction, we should be focused on addressing those real issues. We strongly oppose this bill, and we urge you to consider the negative impacts the passage of this bill will have on our community. Thank you.
Thank you very much. Appreciate you being here to present your testimony. Is there anyone else wishing to testify on this measure, House Bill 1308? If not, questions, members? Seeing none, let's move on. Thank you very much to all the testifiers, and thank you, members, for being here. Let's move directly into decision-making. Back to the top of the agenda, House Bill 1002. Before I make my recommendation as to how I would like to proceed, I wanted to give the opportunity to Chair Bellotti just to explain the amendments that were made in her committee so that we can all understand it more effectively.
Thank you, Chair. So I appreciate that testifiers came in and were requesting a 4-year term. However, I think what's not highlighted is that the amendment made in the previous committee was actually to provide a 3-year term and then allowing the commission to review and recommend the retention of the coordinator. There is no end or set number of terms, so that effectively means that a coordinator can stay on for many, many years. And under this first renewal process, it will be actually a 6-year term. So what this does is this language creates an appropriate check and balance for the authority of the commission and the independence of the coordinator. I think
Thank you.
It's a good balance. So my recommendation, Chair, is, as you know, just to move it on.
Yeah, so I brought this up with Chair Bellotti about increasing to 4 or 6 years. She wanted to keep it at 3 and had the opportunity to explain what her amendment was. And I understand from the testifiers that you were seeking additional, to increase it to 4 or 6. Recommendation from me, following up on the chair of the first committee, is to move this out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1002 HD1 as is. Chair and Vice Chair vote aye. Representative Bellotti.
Aye.
Representative Cochran is excused. Representative Hashem. Aye. Representative Kahaloa.
Aye.
Representative Peruso.
Aye.
Representative Takayama.
Aye.
Representative Todd.
Aye.
Representative Garcia.
Aye.
Representative Shimizu. Recommendation is adopted.
Thank you. Next measure, House Bill 677. I think this bill is in good shape. We'd like to move it forward as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 677 HD1 as is. Noting Representative Cochran as excused. Are there any noes or reservations? Okay, hearing none, recommendation is adopted.
Thank you. Next measure, House Bill 1183. I'd like to recommend we move this out with amendments. I'd like to take the most of the amendments from ERS, the Employees Retirement System. I'd like to, we'll remove all references to the Department of Law Enforcement investigators and replace them with, quote, law enforcement investigation staff investigators, end quote, where appropriate. We'll be amending subsection E of section 88-122 HRS to add the Director of Law Enforcement, Deputy Directors of Department of Law Enforcement, the Sheriff's Division investigators, and law enforcement investigation staff investigators. And we'll be adopting some of the amendments from the testimony from Employees Retirement System, and I'll just mention them without reading all the details. We're going to adopt the ERS, and ERS meaning Employees Retirement System. We're going to adopt ERS recommendation to remove the amendment to the definition of law enforcement investigation staff investigators, section 1, page 2, lines 8 to 11. We're going to adopt the ERS recommendation to remove the proviso on section 4, page 12, lines 7 to 17, as is in their testimony. We'll adopt the recommendation to require the director, deputy director, and investigators of the Department of Law Enforcement, if they're defined sheriff and sheriff division investigator positions, to pay a 12.2% employee contribution rate for members before July 1, 2012. We're going to adopt the ERS recommendation that the proviso, section 2, page 3, lines 14 and 19, requiring the 5 added positions to contribute 14.2% for employees in these positions that become members, be removed. We will adopt the ERS recommendation that effective dates in the bill be conformed to avoid administrative complexity and confusion. And that this would eventually include the overall effective date of the act as well, which we'll put into the Standing Committee report. We'll adopt the ERS recommendation that after the July 1st, 2025 date on Section 4, page 12, line 1, be amended to June 30th, 2025. We also adopt the ERS recommendation that an effective date of, quote, after June 30th, 2025 be inserted regarding the start date for the added Class A members with membership dates after June 30th, 2012. Finally, we'll adopt the ERS recommendation that these additions and amendments are made, quote, notwithstanding Section 88-99 HRS regarding, end quote, regarding the moratorium on benefit enhancements until the system is fully funded. We'll also include technical amendments for clarity, consistency, and style. Those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1183 HD1 with amendments. Representative Cochran is excused. Are there any noes or reservations? Hearing none, recommendation adopted.
Thank you. Next measure, House Bill 1045. I'd like to recommend we move this out with amendments, defect the effective date, July 1st, 3000, make technical amendments for clarity, consistency, and style. I would like to blank out the appropriations and put the appropriations request into the Standing Committee report. And we will use the amounts that are in the Budget and Finance testimony for those appropriations that we'll put into the Standing Committee report. Those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1045 with amendments. Representative Cochran is excused. Are there any noes or reservations? Hearing none, recommendation adopted.
Thank you. Next measure, House Bill 664. I'd like to recommend we move this out with amendments. I was intending to include the Attorney General's recommended amendments. However, I was cautioned against this because of the title problems that it would cause. This measure is relating to gun violence prevention. Their testimony wanted us to merge the Office of Gun Violence Prevention with the Gun Violence and Violent Crimes Commission. And that would unfortunately cause us some title problems. So that's unfortunate. So at this point, until I figure out another solution, I would like to include only the inclusion of the draft grant standards that are in the Attorney General's testimony, but not include their portion of their testimony, which was recommending the combining of the two entities. So we would be also making some technical amendments for clarity, consistency, and style, defect the effective date to July 1st, 3000, and blank out the appropriations and put those into the Standing Committee report. Questions or concerns, members? Representative Shimizu.
Thank you, Chair. I understand your explanation on the AG's suggestion, and I would have voted yes on that, but because that can't be incorporated, and I understand your explanation, I have to vote no on this.
Understood. Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 664 with amendments. Representative Cochran is excused. Noting a no vote from Representative Shimizu. Are there any noes or reservations? No vote. No vote for Representative Garcia. Okay, recommendation is adopted.
Thank you. Moving on, House Bill 508, relating to fireworks. I would like to recommend we move this out with amendments, blank out the appropriation, and put that into the Standing Committee report, defect the effective date to July 1st, 3000, and make some amendments as follows. Page 1, line 1 to 15, that we would actually do the appropriation of the funds in the standard way, rather than what the bill contemplates, which is amending Act 67 of a bill we passed in 2023 to insert the appropriation. That's just, it would cause problems. So we're just going to appropriate the funds in the standard way. On page 2, line 5, we need to amend the measure to add a proviso that the amendments under Section 2 shall take effect on June 29th, 2025, which is 1 day before Act 67 is set to repeal. Those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 508 with amendments, Representative Cochran is excused. Are there any noes or reservations? Hearing none, recommendation adopted.
Thank you. On, you know what, I'm sorry, I read the wrong section. Let's go back and do that again.
Okay.
Let me reconsider that decision, I'm sorry. I read the wrong thing. Okay, let's go back. HB 664, gun violence prevention. I was reading the incorrect ones here. Okay, so let's right, because we just did 664, right? Okay, so I want to redo that vote on 664. Please, I'd like to reconsider that vote. I gave the wrong recommendation. Okay. I said that we're not able to incorporate the Attorney General's amendments due to the title. I would recommend we make technical amendments for clarity, consistency, and style, defect the effective date, and blank out the appropriation. On Section 4, which establishes the Gun Violence Prevention Special Fund, it does not state what the monies in the fund may be expended for. At least one authorized expenditure appears to be for the award of grants to organizations to conduct community-based gun violence intervention initiatives. I would include that to at least provide a specific reason for what the fund would pay for. That's what I would recommend for HB 664. I apologize, members. So my recommendation is to pass it out with those amendments. Questions or concerns?
Just clarifying question,
I
Chair.
cannot, I'm not able to include the Attorney
Okay.
General's amendment, so you can still vote the way you did before. Yep. Okay, sorry, please. What's that? Yeah. So we are reconsidering their decision, and my recommendation is to pass it out with the amendments that I just read.
Okay.
Please proceed.
Okay. Voting on House Bill 664 with amendments. Are there any noes? Representative Cochran is excused. Are there any noes or reservations? Okay, Representative Shimizu and Garcia. Okay, no votes for Shimizu and Garcia. Recommendation is adopted.
Okay.
Okay.
Next one, HB 508. On this one, I would recommend that we move this out with amendments, blank out the appropriation, and put the appropriation into the Standing Committee report, defect the date to July 1st, 3000. And in this one is where we need to make the amendments I described earlier. Page 1, lines 1 to 15. Rather than amending Act 67, Session Laws of Hawaii 2023 to insert the appropriation, we would change it so we would be appropriating the funds in the standard way. On page 2, line 5, we would need to amend this measure to add a proviso that the amendments under Section 2 shall take effect on June 29th, 2025, which is 1 day before Act 67 is set to repeal. Those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 508 with amendments. Representative Cochran is excused. Are there any noes or reservations? Reservations for Representative Garcia. Okay, hearing no others, recommendation is adopted.
Thank you. Next measure, House Bill 648, relating to guardianship and conservatorship services. I recommend we move this out with amendments. I'd like to blank out the appropriation and put the appropriations request into the Standing Committee report, and then defect the effective date to July 1st, 3000, and make technical amendments for clarity, consistency, and style. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 648 with amendments. Representative Cochran is excused. Are there any noes or reservations? Hearing none, recommendation adopted.
Thank you. Next measure that we heard, House Bill 1001. On this measure, I recommend we move this out with amendments. Technical amendments for clarity, consistency, and style. Blank out the appropriation to put the appropriations amount into the standing committee report. Defect the date to July 1st, 3,000. And on page 7, lines 16 and 19, that we would amend subsection F to read, quote, "Any individual who receives compensation from the Maui Wildfire Settlement Trust Fund under this section shall execute a release that releases the state from any and all liabilities arising out of the Maui wildfires, period," end quote. That's my recommendations, and as I said, technical amendments for clarity, consistency, and style. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1001 with amendments, Representative Cochran is excused. Are there any noes or reservations? Hearing none, recommendation adopted.
Thank you. House Bill 1174, I would like to move this out with one amendment, which is to defect the effective date to July 1st, 3,000. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1174 with amendments, Representative Cochran is excused. Are there any noes or reservations? Hearing none, recommendation adopted.
Thank you. Next measure, House Bill 990, making appropriations for claims against the state, its officers, or its employees. I would like to move this forward with amendments to defect the effective date to July 1st, 3,000. I would like to adopt the amendments from the Attorney General to make sure that we've got all the current claims accurately described in the bill and everyone spelled properly, all the names spelled properly, and then also add the additional claims that were provided by the Attorney General in their testimony. I also would like to adopt the amendment from the Department of Budget and Finance. And I want to make sure that on page 3, lines 24, the word Randall, R-A-M-D-A-L-L, would be spelled properly, which I think is just with one L. Those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 990 with amendments, Representative Cochran is excused. Are there any noes or reservations? Hearing none, recommendation adopted.
Thank you. Next measure, House Bill 997. This measure needs more work. There's a wide gap between what the Attorney General is proposing in this bill and what the judiciary says is what's appropriate to do to be in compliance with the Supreme Court decision. And the public defenders have stated some serious concerns with this measure as written. I note that the Senate companion for this measure, Senate Bill 1316, was passed out of the Senate Judiciary Committee and now moves on to the Ways and Means Committee in the Senate. I propose that we defer this measure and wait for the Senate measure to come over in hopes that the Attorney General and the Judiciary and the public defenders will actually work together to figure out the language in the bill that would be in compliance with the Supreme Court decision, but also workable to the judiciary. So that's my recommendation, is to defer House Bill 997. Questions or concerns, members? If not, thank you. House Bill 364. On this measure, unfortunately, this needs a lot of work. And I think that the concerns from the veterinarians, the concerns from the legitimate cat breeders that are in our community have not been considered. And I think we need to consider them to make sure this is accurate. This is a proposal to take care of only the pet population, not the free-roaming feral cat population. I wanted to move this forward with just establishing the fund and take out Section 2, because I do think we need a funding source for spay and neuter. However, I was not able to get prior concurrence for doing that, and so I'm recommending that we defer this measure, and I would ask the proposer to do what was suggested by Mr. Inouye, is to gather together the stakeholders and come up with a bill that would be supported by the advocates on all sides, which I think is possible, but it just needs more work. So my recommendation is to defer House Bill 364. Questions or concerns, members? If not, thank you. Next bill, House Bill 366 relating to renewable energy. This bill has received testimony from people who think it's a great idea and other people who think it's a terrible idea. I am persuaded that this legislature took a lot of initiative to create the environmental court, specifically to deal with these issues. And this measure would basically avoid using the environmental court. And so I don't think that's a wise choice. Yes, I agree that it's a problem sometimes that litigation is used to delay a project so long that the project loses financing and the project fails, but I don't think this is the measure that would address that issue. So my recommendation is to defer House Bill 366. Questions or concerns, members? If not, thank you. House Bill 992. We had two measures. We only heard one. This is the Attorney General's measure to deal with these charitable fundraising platforms. I would prefer to go with this measure as opposed to the other one, so we didn't hear it. So my recommendation is to make technical amendments to this, defect the effective date to July 1st, 3000, and move this on for further consideration in finance. Questions or concerns, members? If not, Vice Chair for the vote. Oh, Rep. Shimizu.
I had concerns that were expressed in the testimony, so I'll be voting no.
Okay, any other questions or concerns? If not, Vice Chair for the vote.
Voting on House Bill 992 with amendments, Representative Cochran is excused with a no vote from Representative Shimizu. Are there any noes or reservations? No vote for Representative Garcia. Recommendation is adopted.
Thank you. Next measure, House Bill 228 relating to license plates. I think this bill is in good shape to move on for further consideration. I recommend we move this out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 228 HD1 as is, Representative Cochran is excused. Are there any noes or reservations? Recommendation is adopted.
Thank you. Next measure, relating to the Public Land Trust Working Group. I think this is a very important measure that we need to move forward. I recommend we just make some technical amendments for clarity, consistency, and style, and make sure that the Standing Committee report includes the appropriations that we are seeking. And it's both a portion of the money from the general fund and portion from the Office of Hawaiian Affairs. And what we would, rather than putting the source of the funds, we just want to put the amounts that are being requested into the Standing Committee report, along with technical amendments for clarity, consistency, and style. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1358 with amendments, Representative Cochran is excused. Are there any noes or reservations? Hearing none, recommendation adopted.
Thank you. Next measure, House Bill 1007. On this measure, I would like to move this measure out with amendments. I recommend that we include the amendments from the Office of Planning and Sustainable Development and the recommended amendments from the Department of Land and Natural Resources, and that I would like to include in the Standing Committee report that this committee requests the Hawaii Community Development Authority to provide language to Finance Committee that they noted that they would like to see in an amendment to the bill that specifically deals with oh, right, no, we asked you the question. We don't need to make any additional revisions, so skip that one. So it's just the amendments from the Office of Planning and Sustainable Development, the amendments from the Department of Land and Natural Resources, and that's it. My recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1007 HD1 with amendments, Representative Cochran is excused. Are there any noes or reservations? Hearing none, recommendation adopted.
Okay, House Bill 958. I recommend we move this out with amendments. I would like to amend page 12, line 11, to replace 15 with 16. For consistency, I'd like to add, quote, or electric micromobility device, end quote, after, quote, electric foot scooter, end quote, on page 8, line 19, page 10, lines 10 and 14. And we'd also amend section 291C-150, parens B, to incorporate the change, increasing the age from 16 to 18 years of age, and then technical amendments needed for clarity, consistency, and style. Those are my recommendations. Questions or concerns, members? I do have prior concurrence from the Transportation Chair for those changes. If there's no questions or concerns, Vice Chair for the vote.
Voting on House Bill 958 HD1 with amendments, Representative Cochran is excused. Are there any noes or reservations? Reservations for Representative Garcia. Recommendation is adopted.
Thank you. House Bill 604. This is a controversial measure, and I appreciate that, but I think that we need to be creative to come up with funding for the Department of Hawaiian Homelands to have them continue the good work that they're doing. And this is one where I think it's a direct nexus between the visitor industry, which promotes and highlights our Native Hawaiian culture, traditions, and values as part of the attraction of Hawaii. This would be an opportunity for the visitor industry to provide direct funding to benefit the Native Hawaiian community that they are using to attract people to come to Hawaii. So my recommendation is to move this out as is and move it on to the Finance Committee for further consideration. Questions or concerns, members? Representative Shimizu.
Chair, thank you, Chair. I have no problem supporting the Native Hawaiian community. I'm against raising taxes and feel the need that we should save by cutting waste and increase efficiency. So I approve moving, supporting it, but with reservations.
So you're yes with reservations? Okay. Any other questions or concerns, members? Representative Garcia.
Thank you, Chair. Again, I do concur with my colleague, Rep. Shimizu. Support DHHL. Thank you, Director, for being here. And there must be more ways and more effort from this legislature to divert funding to Hawaiian Homelands so that that wait list can be removed. Unfortunately, I don't believe that raising taxes is that solution, so I'll be casting a no vote. Thank you.
Understood. Thank you. I appreciate that. And I am trying to find other sources in addition to this, but this is one of them. Any other comments, questions, or concerns? If not, Vice Chair for the vote.
Voting on House Bill 604 HD1 as is, Representative Cochran is excused. A no vote for Representative Garcia and a with reservations vote for Representative Shimizu. Are there any additional noes or reservations? Okay, hearing none, recommendation adopted.
Okay, final measure, House Bill 1308, relating to sports wagering. On this measure, you know, in my career, I have consistently voted against gambling. This is the first time that I'm moving forward a bill that establishes gambling, and the reason why I'm doing it is that we are in a fiscal crisis. We're facing significant cuts that we have relied upon from the federal government, and setting aside the reasons why those are happening, I'm just trying to deal with the critical issue that we have programs within this committee's jurisdiction in Judiciary, Department of Hawaiian Homelands, Department of Law Enforcement, the Attorney General's Office, Campaign Spending Commission, Ethics Commission. We need to continue funding these programs. And the other committees have priorities as well. So I'm trying to be creative and move forward with legislation in a reasonable and deliberative way. So I understand that there's issues with this, but that's my reason to move this forward, because I think we are in a critical situation right now fiscally in the state. So my recommendation is to move this forward with some amendments. I would like to include the Attorney General's amendments. I would like to also make some amendments as follows on page 5, lines 16 to 18. So I would change the definition of sports wagering supplier to match the description for sports wagering suppliers licensed under Section 6, which authorizes the sports wagering suppliers to sell or lease sports wagering equipment, systems, or services in the state. I also would like to insert general language that requires the Department of Commerce and Consumer Affairs to adopt rules pursuant to Chapter 91 to effectuate the purposes of this chapter. I would also amend Section 846-2.7B to require Department of Commerce and Consumer Affairs to conduct criminal history checks. I would also like to include licensees on page 12, lines 10 and line 20, similar to what's done in other paragraphs, because they're missing from this section. I want to include them in there. And then on page 14, line 14 to page 15, line 10, I want to amend this language to make it clear that an applicant for a temporary license is still subject to the limitations, which is only 4 licenses may be issued, as well as requirements of subsection A. And I want to insert similar language that is included on page 17, lines 3 to 21, specifically line 8 to 9, that the applicant meets the requirements established by rule for a temporary license. Lines 10 to 11, the department is not aware of any reason the applicant is ineligible for a license. And lines 13 to 21, which is clear about the duration of the temporary licenses and what happens. But I want to clarify that the temporary license will be revoked if the applicant is considered or determined to be ineligible. Finally, on page 17, lines 16 to 21, I want to clarify that the temporary license will be revoked if the applicant is determined to be ineligible in that section as well. We would make technical amendments for clarity, consistency, and style. And I would ask in the standing committee report that the Finance Committee consider the concerns expressed by the Department of Taxation and make any amendments to address those concerns. Those are my recommendations. Questions or concerns, members? Representative Peruso.
Go ahead.
So, Chair, I deeply appreciate your attention to the criticality of our budget situation. But given my personal history and my firsthand witnessing of the regressive impacts of legalized gambling on communities, I'm going to be a very strong no on this measure.
Understood, and I appreciate that. Please vote your conscience, members. Other questions or concerns? Representative Shimizu.
Thank you, Chair. I agree with the prosecuting attorney's testimony, and I am a strong no also.
Okay, understood. Representative Todd.
We've got to change it up. First time I've talked on anything all year. I just want to appreciate you taking a look at it and at least advancing the conversation. I think generally speaking, the legislature historically is very good at anticipating future negative impacts, but not great at taking a look at the reality of the current negative impacts that prohibition, not just on gambling, but on a variety of issues currently has. Some estimates about $300 million in illicit sports betting currently annually, and over 70 game rooms on Oahu. That's not to say that legalization is going to be, net positive, but I think we at least need to be open to the idea that that may be the case in bringing some light and some revenue out of this. And then lastly, I would like to note that maybe the prosecuting attorney's office or the AGs may want to adjust their testimony in a future committee, should it get there, given that they have a paragraph that is actually identical, and that's not a great look because that suggests kind of broader coordination. That's all.
Thank you very much, Representative Todd. Other comments or concerns? Representative Takayama.
Thank you, Chair. I totally agree with your comments about our dire fiscal situation in the state. However, I'll be voting no because of my concern that by legalizing this aspect of gambling, it would unleash unfettered advertising. And in doing so, it would lure into gambling those persons in our community who can probably least afford to lose money gambling. So for that reason, I'll be voting no.
Understood, and I appreciate your position on that. Other questions or concerns, members?
I'd just like to note my
Representative
reservations.
Bellotti.
Just note my reservations. And I'll be voting yes.
Reservations from Representative Bellotti. Other questions or comments? Reservations for Representative Hashem. Other questions or comments? If not, Vice Chair for the vote.
Voting on House Bill 1308 HD1 with amendments, I have reservations from Representative Bellotti and Hashem, no votes from Representative Peruso, Takayama, and Shimizu. Any additional noes or reservations? No vote for Representative Garcia, and Representative Cochran is excused. Recommendation is adopted.
Thank you. There being no further business before this committee today, we are adjourned.